I'm calling this meeting of the Board of Zoning, Rappahannock County Board of Zoning Appeals to order. And the first item I'll call the roll. Jennifer Matthews.
Here.
I'm Alex Sharp. I'm here. David Conner. Here. Ron Macro. And Chris Burrs.
Present.
And Michelle Summers is our zoning administrator. We have our court reporter here. And Mike Lockerbie is here, and he's going to advise us this evening. He's from Salem, Virginia, and he's advised us on a number of things, and we value his opinion, so hopefully he's given us some advice so far and may weigh in. Okay, the first item, we're going to have our organizational meeting, and Michelle will take over for that.
With the new year upon us, all the officers who hold a seat on this board, as in chairman, vice chairman, secretary, FOIA officer, will all vacate their positions, and we will now elect members for those new positions.
Hold on.
I would open the floor for nominations for chairman.
I nominate Alex Sharp for chairman.
I'll second that.
We'll need a second for nomination.
Any other nominations?
I'll nominate Ron Macklin. And move the nominations be closed.
I'll second that.
Okay.
Okay, our first nominee for chairman is Mr. Sharp. I'll take a roll call vote. Mr. Byrd?
Yes.
Mr. Macla?
Nay.
Mr. Connick?
Nay.
Ms. Matthews?
Yes.
Mr. Sharp?
I'll vote yes.
That is a 3-2 vote.
Okay.
Okay. Then the next item is election of the vice chairman. Are there nominations for the position of vice chairman?
I nominate Jennifer Matthews.
Are there any other nominations?
I nominate Ron Macklin.
Is there a motion? Is there any other nominations?
I move that the nominations be closed.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Okay. Roll call vote for Jennifer Matthews.
No, you have to vote all the people. And they say who they're voting for.
Okay. Chris, who do you vote for?
I vote for Jennifer Matthews.
Ron?
I'll vote for Jennifer Matthews.
David?
I'm going to abstain.
I'll vote for Jennifer Matthews.
For myself, thank you.
Okay, for the position of secretary, are there any nominations?
I'll nominate David Conner.
I second that nomination.
Are there any other nominations?
Yeah, I'll nominate Ron Macklin.
Is there any other nominations?
I move they be closed.
Okay, the nomination's closed.
You have to vote on it.
Okay, is there a second to?
I second it and close the nominations.
Okay, all in favor?
Aye.
Okay. Jennifer?
I vote for David Connick.
I vote for David Connick. David?
Vote for Ron.
I'll vote for David Conner.
Chris?
I'll vote for David Conner.
Okay. Now, the FOIA officer, is there any nominations for FOIA officer?
I'll nominate Chris Byrd.
I nominate Ron Macklin. I can do it too.
Are there any other nominations?
I move they be closed.
There's a second.
I'll second it.
All in favor?
Aye.
Okay, Chris?
I vote for Ron Macklin.
Ron Macklin?
I vote for Chris Byrd.
David?
I'm gonna pass and see what you guys.
I'll vote for Ron Michael.
I'm gonna look for Ron Mackler.
Okay.
Well, I'll make it unanimous. Oh, no, what do you know? Did you vote for it?
He voted for you.
I have to get on the winning side or something.
Well, you'll have time. The board of, the BCA representative to the planning commission has already been selected. They were selected by the board of supervisors at the January meeting. So this time, we did not get the opportunity to nominate someone.
Point of order, according to our procedures, that is part of our process at this meeting.
You're saying we should go ahead and do it anyway?
Absolutely.
I'll yield to that, I guess. Is there a nomination to that position?
I nominate Chris Burke.
Is there another nomination? Okay, is there a motion to close the nominations?
I so move.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Okay. Jennifer?
Chris Burke.
Chris
Finish up
Burke?
the
Well, I think
comprehensive
he's-
plan.
If the
Well, I mean-
nominations are closed and there's only one candidate, I guess you just declare him elected. I'm gonna abstain from it.
I'll vote for Chris Burke.
Okay. I think that covers that. Now, the annual meeting schedule, do we have that written? It's the
Yeah.
fourth Wednesday of each month?
Especially December 25th.
Is that the day before?
Where is that?
Get back on there.
So maybe we
Well,
should
we
look.
want to do November and December because we usually
Yeah.
change those. Okay.
So we post this is the meetings for the entire year, that we post the regular meetings. So we meet FOIA requirements for posting the dates, and then we email this out to the email list. So what about December?
What about November? I don't have a calendar.
But
What day is that?
November is after Thanksgiving.
A week after?
The Wednesday after Thanksgiving?
When's Thanksgiving? The 3rd?
Fourth.
The 4th? Oh,
Yeah, but that's fourth
this
Thursday.
day. So then it was,
Where's Thursday?
that's Thursday.
Okay,
So-
so it's the 28th.
So then we're gonna have to probably change that because it's the day before Thanksgiving next year.
Do you want to make it the week before
Let's
that?
make it the Thursday before.
Or do you want to combine November and December?
Which we've done before.
Okay. So what would be the 3 weeks? And this room would not be available, right?
Okay, maybe.
On the third Wednesday?
No, because the planning commission will be meeting.
So to make the Thursday is what you.
The 21st.
That's the day after the planning commission, yeah. So November 21.
And what about Christmas?
Yeah, we can meet on Christmas.
It's at night.
So we'll be all done. Okay. Is there any other ideas on that?
Let's just wait until we see,
Well,
what's
we don't
coming.
want to leave it scheduled for the 25th.
Then you're gonna
No,
have to put out notices and such.
All right,
So why don't we
So why don't we back it
determine-
up 7 days?
do the same thing with the previous Thursday?
Wednesday.
Well,
the
planning commission.
Previous Thursday is what?
so the Thursday would be the 19th.
Good.
Okay.
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 The 19th.
So is there a motion to,
We've got a thing on here for the 22nd. It's regular and organizational
of January?
of January, but we've run into a problem this year in that the BZA person is part of the organizational meeting appointment.
Good plan.
So maybe we should break that out.
Well, we can do that in December, I guess.
Yeah, we can change our procedures or whatever, but
Our rules say that.
the way the rules and procedures read right now, that appointment is made the first meeting of the year, in January.
But you're talking specifically about the planning commission representative?
But that's, according to our procedures, that's when that is made. And
Well,
so
now
we need
when-
to either change our procedures or something, because there's no sense doing what we just did. It was sort pointless.
You mean approving someone who's already been approved, or recommending someone?
Well, plus we have no say in it then. Just 2 years in a row now, we haven't had a say in it.
We have a say, we just got ignored.
Well, yeah.
There's a difference.
But I don't know that we need to move the whole organizational meeting to
No, Gary.
December. We can just, do we need to even note that? We can
Well, we
just,
have to, at some point between now and November, change the rules to say that in the
Yeah.
December meeting.
right, the December
that
meeting will
do
make the
the
recommendation.
recommendation, so that they can ignore it in a timely fashion.
Okay.
That
So,
will be duly noted in the minutes, in the agenda.
court reporters.
Is-
What,
You're not
you
doing
duly
the
ignored?
reporting now.
No, that it is,
Yeah, but that doesn't mean that she's
But it
gonna,
is,
she doesn't have
uh,
to transcribe
what do
it,
you call
Okay.
it?
Okay.
Planning for that last meeting.
but.
Hopefully, one of our younger members will remember to do that before.
Okay, so we can just deal with that during the year. Great. Okay, is there a motion to adopt this annual meeting schedule as revised?
I so move as it was amended to November 21 and December 19.
And these are all at 7 PM in this room?
In this one,
Okay.
unless we get booted for some unknown reason.
Is there a second?
I'll
Second.
second it.
I'll take Jennifer's second, I guess. All in favor?
Ignore it.
Aye.
Aye.
Okay. Now we're looking at adoption of the agenda. Are there any changes, additions, or deletions from the agenda that anybody wants to, or in the order?
No, I move that we adopt it as
Circulate.
amended or as it was circulated.
Is there a second?
I'll second that.
All in favor?
Aye.
Aye. Okay, now the minutes from December 20th. Jennifer, you had a small correction.
I've given that to the
You've given
secretary.
that, is there anything else?
I don't know.
On the minutes?
I just want to note in the record, this was authority for you and everything, I'm not allowed to participate in the discussion of the part of the meeting from last month that I was recused from. So I'm not going to just, I can't say anything, but I will say I think there was some maybe possible math errors.
There was a math error.
Okay, can you share that?
Yes, there was a misunderstanding on the counting of the days, on when the days start, and that I've come to learn that the day we start counting is the day after it is mailed, not the day that it is mailed, so that would change it to the 21st was the final day that we could accept the appeal, rather than the 20th.
And that doesn't affect what we...
It does not affect the results, but for, you know,
So
For
it's-
future.
Okay, well, that's good to know, thank you.
The 30 days is up anyway, so it didn't get appealed, so it
Correct.
doesn't matter anyway.
I mean, that's
You mean,
good to know.
That
So
ruling did not
What?
appeal.
yes.
so it's
Okay.
mailing plus one.
Yeah, you start on the next
Okay.
day after.
I'm not talking about any particular case, but there's a statute, there was, I think it's 1201 or something like that of the Code of Virginia that says when you start have to compute the time, you don't count the first day that it was sent, you start counting the next
On the
day.
next one.
And if the deadline falls on a Saturday, Sunday, or holiday,
We go
it
to
pours over to the next business day.
So if the last day is the 30th day,
If the 30th
If it's
day,
30 days.
if it's 30 days and the 30th day falls on a Saturday or a
Then it goes to
Sunday,
then it
Monday.
goes to...
or Lee Jackson Day, it rolls over to the next business day after that.
Okay. Are we making a change to the minutes to reflect that?
Yes, I would propose that change
Okay, you can get that.
for accuracy's sake.
You need to sign it.
Okay, is there a motion to accept the minutes
As amended, yes.
as amended?
Can you change that?
Is there a second?
I'll second it.
All in favor?
Aye.
Abstain.
Because of your...
My part's right, but I'm just going to abstain.
Okay, the next item on the agenda is probably what everybody's here for, is the appeal
For
of...
the election?
What's that?
You don't think they were here for the election?
No.
I don't think so.
Okay, it's the appeal of the, Bill Freitag and Patty Hardy's appeal of the zoning administrator's letter of opinion relating to Williams Tree Service. And the first issue, since it was brought up by Mr. Hampshire, was whether a motion or a request to ask David Connick to recuse himself from this permit discussion and participating in it. And do you have anything further to say about that?
Nothing further, no.
Okay. And we've gotten legal advice from Mr. Lockerbie that suggests that we really, as a board, we really don't have the authority to recuse Mr. Connick, that would be his decision as to whether to recuse himself. So we can vote on this motion to deny it, or we can just pass that by. But it doesn't sound like we have, I mean, we can make this determination, but it doesn't sound like we have the authority to do that. Would you entertain a motion? Would you make a motion, someone? Or have a discussion?
I was going to say, does it take a motion, in that we can't rule on it anyways, or do we?
Well, we can say,
You need to
Or we
make
can-
a decision as to whether you think you have authority to act upon it.
Oh.
so either we
You
do.
can either grant or deny Mr. Hampshire's motion, and your reasons for denial might be that you don't believe that you have authority to grant the motion.
I'll make the motion that we don't have the authority to make that motion.
So we're
It's a personal, question between two individuals, and I don't think we have the authority to rule on that.
So you're making the motion that we are making the finding that we do not have the authority to rule on this, is that?
That's my motion.
And therefore, he's denying Mr.
And therefore we'll deny his request. Is there a second to that?
I'll second that.
Is there any further discussion? All in favor? Aye.
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 No.
Are you
Abstain.
Okay, so that's 3 ayes, a nay, and an abstention. Okay. Now, we have a couple of other issues.
Well, before you go on, Mr. Chairman, I'd like to respond to it.
You're talking about responding to their request?
Yeah,
that you reviewed.
because they asked the board to do it, or they asked me to do it, and so I'd like to respond to it,
Okay.
if I may.
Yes, you may.
Okay, somewhere on my papers got mixed up and wrong. Hold on a second.
Mr. Chairman, I guess I do have a point of order. If the board has voted to deny my motion, it seems like the matter is over and we're ready.
Well, it's not over as far as I'm concerned, because
Well,
I have the authority to
He would
recuse myself
he
or
would
not.
have the option of recusing himself. I think you've made that request, so
All right,
I think this is an answer to that.
all right, very good.
Pass it down, please. I'd like to have this put in the record.
Do they have a copy?
We have one copy.
Mr. Chairman, since I've been on the board and before that, at many hearings and proceedings of this board and other boards, when it comes to zoning, I think I've always taken the position that zoning is a matter that should be determined based on the property and the zoning ordinance and the state law, not on the basis of personalities. And I have never deviated from it, and I haven't deviated from it in this case. And as far as this motion goes, it claims that I have some kind of personal bias that prevents me from acting impartially and fairly based on the evidence that comes before us tonight and based on the law. And I just want to state categorically that I don't have any such bias against Patty or Bill Freitag. I've known them for quite some time, and they took my zoning course a few years ago, and they know what I just said is something that I always emphasize. And so that's just not a factor here. The materials that were attached to this motion were selectively culled out of a bunch of emails and correspondence back and forth, and the document that I just handed back and forth back amongst the board, which I would like put in the record, is really a full record of it. And I'm not going to rehash everything that went on and why I made the comments that I made, but I just want to say that that doesn't have any bearing whatsoever on my decision in this case, and therefore I have no intention to recuse myself. Thank you.
Thank you, Mr. Miller. Okay, now we have the appeal that we're about to hear now that we can get down to that is Michelle wrote a letter to, is it Bob Mann?
Right.
Who,
And the new residents.
and the Benvenue residents. Now, you were not named specifically on his letter, is that correct?
Yes, she was.
Right, are you?
All of us were.
All of you, okay.
Yeah, we're all named.
All
Okay,
of us.
okay,
Well, most.
okay, I got it. And anyway, so Michelle wrote a letter in response that answered or attempted to answer the questions. And then Bill Freitag and Patty Harvey you helped them make their appeal application. So that's basically what we're hearing tonight, is the appeal to Michelle Summers' ruling that was in the form of a letter. And it's a number of different, if I understand correctly, there's about 5 or 6 different assertions that you're making.
Yes, sir.
Mr. Chairman, I think that the zoning administrator first goes to explain her decision, and that would be followed by the appellee's, or excuse me, the appellant's rebuttal of that, and then it's up to this up to this board, well, and then also the landowner, if they wish to speak, is also guaranteed equal time. If they wish.
Okay. Fair enough. Michelle, would you like to summarize your position? Please swear. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes. Again, for the record, I'm Michelle Summers, I'm the zoning administrator. I did go out to the site, I took the special use permit that was granted to the Williams Tree Service. I compared the special use permit to the site. I found one violation, that the logs were stored too close to the road. I cited that violation, sent a letter. That violation was resolved, and that was closed out, and that was the only violation I found at the site.
And you made a couple of other determinations. That's all you wish to say? Art, do you have anything to add?
You want to come up there?
Yeah, sure.
With regard to the vested rights determination,
Would you mind introducing yourself?
yeah, I'm Art Goff, I'm the county attorney, nice to meet you, sir. And so county position is that the permit was issued, I believe, 2007, amended in 2012, that it was pursuant to the authority that the board has to make a special exception, that it was unappealed at that time. There was no 30-day appeal noted to what the board decided. It was a hotly contested hearing. There were opposing views, and under a fairly debatable standard, the board chose to grant a special exception and then to again modify it some 5 years later. It still exists now. It's our position that under the applicable state law, with all due respect to Mr. Hampshire's argument, that it is a vested right at this point under 2 statutes, the first being the vested rights statute and the second being the appeal statute of repose with regard to, I believe it's 522285. It being an unappealed, legislative determined determination is in effect. So we think, as a threshold matter, it's the appeal is somewhat time barred. It's like a collateral attack on something that happened, back in 2007. So we don't think that the posing of the question and the making of the complaint to the zoning administrator now restores jurisdiction, so to speak, to decide the issue once again, once the legislative determination's been made. So I would point out a close reading of, is it 2307? Mr. Gifford has made an argument that, hey, that only applies if there's a subsequent zoning that would make the property non-conforming. I disagree. I think that if you read the plain language of it, it is it's two parts. One, it says it's vested, and then it also goes on to say, and guess what? Even if they do make a change to the zoning ordinance, it's not going to affect that right. So all due respect to Mr. Hampshire's argument, I respectfully disagree with that. Then there's the issue of standing. The county can see that perhaps, arguably, it's a nuisance to look at wood piles as you drive up and down the road, but no one has a property right in somebody else's pretty property. There is, we think, no particularized harm, that's the county's position, with respect to these folks that isn't suffered by the public generally. So therefore, under the Friends of Rappahannock case that Mr. Connick's very, very familiar with, and I'm sure you all are too, we don't think that the folks here have standing to challenge it on all three of those bases. Thank you.
And can I ask a quick question?
Yes,
There was
sir.
something brought up about the void ab initio issue. Does that fold in with the vested rights?
Well, to be void ab initio, I think you would have had to have some major defect in that advertising. There was a public hearing here. There was a public hearing in 2007 and a public hearing in 2012. I don't see how, what's that?
When they wanted the planning commission too?
That's right, there was a planning commission hearing as well. It was properly referred. I would be singing a different tune if it hadn't been properly referred pursuant to 2204, whatever, 2244, to the planning commission for a recommendation and then a public hearing. But that's not the case here. Those are not our facts. Thank you.
Let me ask you a question.
Go ahead.
Mr. Goff, I guess this is related to the chairman's question. I've reviewed the minutes, and I guess before I ask the question, I'm going to assume that you've reviewed them too that are in this filing package.
Can you refer me to the page, Mr. Conley?
Are you talking about the original permit?
Right.
Meeting? The supervisors? Meeting?
Right. So, I think that, well, maybe Mr. Hampshire can help with what, thanks.
Page 9.
Page 21.
Page 21.
Oh, wait, I remember.
All right, I've got it.
Oh, yeah.
It starts at 21 and then, okay. It looks like it's at the top, it's really on page 22.
It's okay, I pulled those special ones out.
And it's, it looks like it's the Board of Supervisors minutes. I'm not sure what book it is, but it's pages 483 and 484 at the top.
Right.
Now, I guess my question is this, and I thought that there was some other place where the full minutes.
There was, they were
Where
colored, they were highlighted.
Where
The
is that?
portion was highlighted.
Can you help us out here a little bit?
Yeah,
I mean, this is just, looks like the conditions, but there's the actual minutes.
that would be in the original appeal statement, my December 13th.
Right.
And,
In the original appeal package, because what I've got is what you filed the other day, and I only got that
that would
electronically.
be exhibit B of the original appeal package.
B? Right, that's what I'm looking for.
I have it right here,
What page
Mr.
is that?
Connick. Oh, you got
Yes,
it.
it's got, it looks like it's exhibit B, or I don't know, it's got exhibit D down at the bottom.
What do you have down?
Oh, sorry, no, that's the review, I'm sorry.
Yeah, we said
Here we go. Right. It's exhibit B, and it's, at the top it says 478, and then it goes over on to 479. Do you have that?
No. Mr. Jackson has kind of provided that to the current.
Very good. Are you with me there?
All right, zoning text amendment, automobile sales.
Next, the bottom full paragraph.
Shop, yeah.
Okay, and it starts out, Greg Williams has applied to operate a landscape and tree service snow removal business from his home property. With me?
Yes.
All right. It goes on 1, 2, 3, 4. About 10 paragraphs over onto the next page. Got a list of the people who spoke, including, I note, Mr. Macula spoke. And then, there being no other speakers, the chairman closed the public hearing. And so I'd like you to sort of focus on the last paragraph that says, following the discussion among themselves on motion of Mr. Welch, seconded by Mr. Lee, the board voted unanimously to approve it, condition upon the applicant's proffers and so forth and so on. Then there was a roll call vote, and it was unanimous. But my question with all that background is, if you look at the zoning ordinance, specifically section 170-52, which applies across the board to all special use and special exception permits granted by this board or the Board of Supervisors. Reed, you have that? Okay.
What are you looking at, the findings?
Yeah, the general standards.
Comply set forth with the general
You
standards.
said 50 or 52?
52.
52%, don't say.
What are you getting
You got it?
Yeah.
Okay. In this board, in my experience, is that those general standards, the board is supposed to make findings as to each one of those conditions, unless they're not applicable, in section 170-52A through J. And and I don't see anywhere in the minutes of this Board of Supervisor meeting back in 2007 where they made any findings at all.
And I'm sure that's probably true for
Okay.
all, if not most of the.
All right, my question to you is this. Does that, because I think that's one of the points that Mr. Hampshire's made, at least ways in his filing, we'll hear from him. But my question is, do you think or how does that impact, I guess, the question of whether or not the permit was void ab initio, because they didn't make those findings and it's apparent from the minutes?
Well, because what authority is there that they have to make specific findings on the record? I mean, is it possible that they simply made these implicitly? I mean,
You mean that if they actually approved it,
they had to make the decision, they're presumed to follow the law. So I don't know that I'm not, at least I'm staying corrected. I'm not generally familiar with that they've got to go down a checklist or something like that and say, oh, okay, well, items A through J have been checked off and we're finding that it doesn't matter. In fact, on all of this, I'm not so sure.
Well, I mean, we typically do that as a board. I don't know what the practice of the Board of Supervisors is. But my question, I guess, is if you look at, for example, Article 6, which is the total article on special permits and special exceptions, Section 170-47, subsection G, says a special permit or special exception will only be granted if the applicant can satisfy the requirements of this Article 6, and the proposed use is otherwise lawfully permitted. So,
David,
that's my question is, and I think I understand your answer, but I just want to clarify that. But, and then ask you a second question, assuming, well, if they didn't satisfy that, is your position that the fact that it wasn't appealed within 30 days makes it appeal-proof under 2285?
I'm afraid so.
Okay. Yes.
Because
All right.
I think that the same argument, suppose they forgot to check off one of the little boxes, then you're saying it would be void ab initio under your logic. But I'm not saying that's
Well,
logic.
I'm not saying, I'm asking you.
I know, but under the question that's posed, the implicit logic of that is if they make a mistake, if they're an error, then it's void ab initio. That's not the law. And additionally, you have the saving provision that there is a time limit on when these errors could be brought to the attention of the competent board or court that would address it.
And that, I guess I have another kind of legal question to ask you. Let's say, for argument's sake, the board comes to some conclusion, after hearing Mr. Hampshire's eloquent argument, presentation, that there was some defect in the original permit. What's your opinion on how this board, as a board, could somehow counteract or countermand the decision to issue the permit of another board?
I don't think you can. I think that under the way our code is written, and I think the state law says it too, that only the issuing board can revoke it. Okay? If this was a special use permit under our bifurcated system, this board would be within its rights to vacate it. Okay? Yeah, revoke it. But not since it's issued by the board of supervisors. So I think they're kind of in the wrong court, so to speak. They should be before the board of supervisors saying, we want you to revoke it because that Williams has abused the permit in some way in their view by enlarging its use beyond what was originally contemplated or intended, so forth and so on. But I think that's the proper place to do it. Because even if they get a writ issued and they go upstairs to the court, what's the standard that's going to be applied by the circuit court? Fairly debatable. So legislative decision. So I think it's spinning the wheels.
Well, I think it's a matter of subject matter jurisdiction, because I have a question about whether this board has, what if we overruled the zoning administrator's decision and said, yeah, they've done something in violation of the permit conditions.
What's going to happen?
So what?
Yeah, it's all.
Because she reports to the board of supervisors, not to us, so then
Exactly
what
right.
happens?
It's a tempest in the teapot because there's virtually no action this board could order the enforcing agent, i.e. the agent or the zoning administrator to take on.
Then we likewise don't have any authority to tell the board of supervisors what to do either, right?
No, you don't. Now, there's a curious crossroads. I was very closely reading again for the umpteenth time, the powers of the Board of Zoning Appeals. And you have to hear and determine the cases that arise under that article. But I think that doesn't take away from the authority of the Board of Supervisors that's also equally granted under this. So I don't think you sit as an appellate body, so to speak, of the actions of the Board of Supervisors. And I think there are limited circumstances even where a court is going to interfere with a legislative decision. But certainly the time has passed in this case, and I respectfully ask for you to so find.
And one final question, unless there's others. But my question, Brian, you have one? Okay. Well, just very quickly. So the position of the county is that there was only the violations that were listed in her violation letter?
Yes, that's my understanding.
Placement of the logs, right?
And placement of the logs, and basically that's been resolved.
The logs, I understand, have been moved. I'm not here to testify, but I go up and down that road all the time, and they have been moved. I don't know if they're 25 feet or 24 feet or 29 feet.
That's the one issue.
The zoning administrator went out there, and she apparently had some kind of measuring device, and she determined that they were in violation, that they were within the 25-foot setback. Now that, according to her testimony, sworn testimony, that's been remedied. That's the only violation she found when comparing the site to the list of conditions.
Okay. Ron, you had a question?
Yeah, in regards to the vesting, does the fact that it both times it was voted on by the Board of Supervisors that they added that 5-year review onto it. It means that it was going to come back up for, to be looked at.
For what? 5-year review for what? They do it all the time, and I don't understand where the authority comes from for the 5-year review. Just as an aside, but it didn't say what they were gonna review. So it's like lightning.
But it implies that there's sort of a 5-year, it's not a permanent.
Yeah, well, as it's written, that thing is permanent. I mean, the 5 years has come and gone too, right?
Correct.
Yeah. So no action was taken, so I don't think there's been any disturbance of the list of conditions as they were originally issued.
I just don't have a question, just a comment. We, as the Board of Zoning Appeals, we go through this 170-52, the general standards, and that's about parking, vehicular traffic, and use of signs and so on. And when I was looking through all these materials, voluminous materials, a lot of the stipulations that were put on the Williams Tree Service are parallel to what these regulations are. So I know I was there at the meeting and whether they went down to the checklist, but what they agreed to is very close
Yes, ma'am.
to what we have, hours of operation and so forth. So a
It
lot
would
of that
seem
is
to
there. So
reflect.
I don't know that it was reflected. I read parts of the minutes, and it wasn't saying that we go A, B, C, and we do the checklist on that, whereas they did not do it, but it's there partially.
I would say that argues that they did consider the fact as they were supposed to, even though it wasn't explicitly stated in the minutes. We don't know that. We can't presume one way or the other.
Or someone did it. Someone did.
Well, obviously the board did because they voted on that
Right.
set of conditions.
Okay. Right, okay.
I'm sure Mr. McCarthy briefed them thoroughly.
Okay, so next, Mr. He's speaking for the applicants. Appellants.
Mr. Chairman, members of the Board of Zoning Appeals, my name is Gifford Hampshire. I'm with the law firm of Blankenship and Keith, and I represent the applicants, Patty Hardy and Bill Freitag. I'd like to start off by handing you up our proposed findings of fact and conclusions of law, which I did email earlier today, and because I think they're based upon the earlier testimony, there's some confusion about what our request for relief is. So I'd like to hand those out if I could.
Did you put one?
Pass one to
Thank you.
council.
You have one?
You're not having
We'll give it to
Let me say that I represent not only, I represent Ms. Hardy and Bill Freitag. I'm also here as supported today by the other Benvenue residents, namely Ann McLean, Sandra Renzi, Bob Mann, Joanne Mann, Susie McLean, Len McLean, Laura McGill, and Charlie Tompkins is also here, I believe. We will call on these folks in our case in chief to make our case. We also rely upon our submissions, which are the December 13, 2018 appeal package, which contains exhibits A through F that we've been discussing, the December 18, 2018 supplemental statement, which contains an exhibit A we'll be talking about in just a minute, and the large package dated 1/17/19, which contains roughly 102 pages, which are numbered, which we've been referring to earlier today as well. The zoning administrator letter dated November 5 is Exhibit A to our package, and the Mann letter to which it responds is pages 2 to 4 of the large packet that I've handed up. We're going to do a couple things in our case. First of all, we're going to address the standing that Ms. Hardy and Mr. Freitag have to bring this appeal. we're going to address these legal arguments that you've heard earlier today, namely whether this board has jurisdiction. And we're going to address the vested rights issue that you talked about earlier today. And specifically, consistent with these findings of fact and conclusions of law, we're going to ask you to find that the zoning administrator is incorrect when she says that this use is saved from not being allowed by the zoning ordinance in the first place by 15.2-2307. And I'm going to cite to you a Virginia Supreme Court case right on point that says that a use that is not permissible in the first place is not entitled to vested rights protection. And that really is our void ab initio argument. It has nothing to do with procedure. It has to do with the fact that this use, it does not fall within the definition of contractors' office, shops, and material storage yards. And therefore, the Board of Supervisors had no jurisdiction to approve a use that was not allowed by its own zoning ordinance.
Mr. Hampshire, can I'm sorry to interrupt you, but I have a question on that before you get too far away from that. My question is simply this. Let's say you're right. What authority does this board have to make a finding in that, like what you're asking us, the finding that you're asking us to make? Let's say we agree with you that the Board of Supervisors didn't have authority to grant the permit that they granted. How do you get around the restriction of section 15.2, 2285 F, or is it J? I forget now. F, I think, that says whatever happened, you have to, your clients or whoever was there, whoever objected to it at the time, had a 30-day limit to take it to circuit court. Because to me, when I read that, and I, suffer under the same, burden as you, I'm an attorney. So when I read that, that suggests to me that only one body has subject matter jurisdiction to deal with it, and that's the circuit court on appeal. So that's what I would like to hear. How do you get around that?
Well, Mr. Connick, you are certainly correct. This board has limited jurisdiction. Its jurisdiction is limited by statute, and specifically, its jurisdiction to do anything today is limited by 15.2-2312. And that statute, as we say in our filings, allows this board to affirm, in part, reverse in part, or modify a zoning administrator determination. And that is all as set forth in these conclusions of fact, findings of fact and conclusions of law. That's all we're asking the board to do. We are not asking the board to declare this use illegal. We're not asking it to enjoin this use. We're not asking this board to do anything but say that the zoning administrator's letter is wrong. That's all we're asking. We can decide what to do with that later. Should it not be appealed, if we're successful, we can decide what court to bring that ruling in and how to use it. And we might be barred in circuit court. There might be an argument on this other side that said exactly what you just said. You can't use this reverse determination. You can't use this BZA ruling to collaterally attack a permit, and that's what you're trying to do. And I would have a counter argument to that. But the point is that the circuit court would make that determination in the context of its jurisdiction. But all this board can do is to say whether or not the zoning administrator is correct in these 3 points that she sets forth in this November 5 letter. The first one being, that this use is, essentially, in so many words, it doesn't matter whether this use falls within the definition of contractor shop, office shop, or materials yard. As Mr. Mann said, it did matter. It doesn't matter because it's vested. This board can listen to these arguments that it has already listened to, whether it's vested or whether it's not vested, and make a determination who's right about that, and say the zoning administrator was right or wrong. That's what we're asking you to do. No more, no less. So that's it. So I'll move on if that's answering your question.
All right, what's the case that you cited for the proposition that the board can't grant a permit? Is that one of the things that's in your package?
You're talking about the supervisors?
Yeah, the supervisors can't grant a legal permit for a non-permitted use.
17049, limits of authority.
In the zoning?
Yeah.
That's us.
No, I'm sorry. The case I was referring to, if I'm correct, is the case of page 82 of my package.
Right, Okay, can you pronounce that?
And that relates to vested rights.
Is that okay?
No, that is Canadian versus Board of Zoning Appeals for Fairfax County. And if you look, that case involved it's out of Fairfax County. Excuse me, that's not the case, pardon me. It's actually the Norfolk case, Norfolk 101
It's
case,
easier to pronounce too.
which is at page
85.
85, and if you look at, that case involved a couple of bars in the city of Norfolk, a cafe and a bar, that had been in operation for some time, and pursuant to a permit, pursuant to a rezoning that purportedly allowed them to operate. And that zoning ordinance was repealed, and the court held that they had no lawful right, even as a result, to do what they had been doing for some time. And if you look at that case, you will see that it says that that 15.2-2307 relates only to a use that was permissible in the first place. At the bottom of page 89, that code 2307 only vests rights in a permissible use, citing the Unedited versus Board of Zoning Appeals case. And also, if you look over elsewhere on page 91 of the opinion, footnote 3 on the first column, the court says the clear intent of this statute is to provide a property owner with protection from a subsequent amendment to a zoning ordinance when the owner has already received approval or made substantial efforts. So it has to be a subsequent amendment to the zoning ordinance. And over on the right-hand column, citing Unedited, it says provides for a vesting right of a permissible use, and held that if the use is not permissible in the first place, this statute doesn't apply. So there are two bases for our argument. One, this use, because it does not fall within the definition of contractor's shop and material storage yard, and I don't think there's an argument that you can make that it ever did, is not a permissible use, never was a permissible use. The fact that Mr. McCarthy wrote a memorandum saying it was a permissible use, it fell within the definition, didn't make it so. So it doesn't apply for that reason, and it also doesn't apply because we're not talking here about a subsequent amendment to the zoning ordinance. We're talking about the same zoning ordinance. So this vested rights statute does not apply. And interestingly, if you look at the vested rights law that predated this statute, going back to the 1970s, the city services case and another case, those cases also say the same thing. In fact, the General Assembly codified that case law in the 2307 statute, that it has to be a lawful use in the first place. And the courts make an interesting distinction. The Unedited case makes this distinction between 15.2-2307, which is the vested rights statute we're talking about, and 15.3-2311, 15.2-2311C, which is where the zoning administrator issues an opinion and that's not appealed, and 60 days goes by and there's material good faith reliance upon that, then there's vesting in those circumstances, even if the use was not lawful in the first place, because the zoning administrator, even if the zoning administrator is wrong, if the property owner relies upon that determination, then that creates vesting. We don't have that situation in this case. So the point being that the Virginia Supreme Court has specifically said that the use has to be lawful in the first place, and there has to be a subsequent amendment to the zoning ordinance for that vested rights protection to apply. And it's interesting to see when you look at the Unedited case and you look at the Norfolk case, both those cases involve substantial hardship for the landowner. There was a case where these restaurants and bars had been operating for a long time. They had invested a lot of money in this operation, and they justifiably felt that the rug was being pulled out from underneath them. Likewise, the people in the Unedited case, they had constructed a house in reliance upon a permit that was unlawful. And yet the Supreme Court said that, estoppel, the general rule, estoppel does not run against the government. If it's an unlawful use from the beginning, i.e. void ab initio, then nothing you can say And that gets me to the other point about the 15.22285F. There's no obligation to appeal a void act. And this would be my argument in the circuit court if I ever got there. If the act is void from the beginning, it's a nullity. And therefore, a landowner should not have to appeal it to circuit court. But I don't want to get too far in the weeds on that, because that's an argument I would make to circuit court should the BZA agree with me. Again, what I get back to is the BZA's obligation in this case is to look at the November 5 letter, evaluate it against the arguments that we've made, and determine, pursuant to findings of fact and conclusions of law that I've issued, whether or not that zoning administrator is right or wrong. And we will prove today that we do not think she's correct. We don't think she's correct in attempting essentially to validate a use that was not subject to a 5-year review that was specifically legislated by the Board of Supervisors in the minutes that you have referred to. Now, there may be some question, as Mr. Goff says, about what the Board of Supervisors meant by that, but there certainly was not any such question in October of 2012 when the board took it up. It knew exactly what to do, and if you look at the exhibit of those minutes and these materials, the board knew exactly what to do. It conducted a public hearing, it heard from everybody, and it made a determination in October 1 of 2012, I believe, that the use should move forward with some modification of those conditions. For some reason, when we get to 2018, September of 2018, September 5 of 2018, which is a footnote in my original filing.
18 or 17, sorry.
I think it was 18.
Just recently.
Well, the 5 years after 12.
Well,
I would say, like you did once in public, but, you know, I can add.
You didn't have it within 5 years at all, right?
Well, while we're on that topic, if you don't mind, I have a question about that, and that is, referring to what Mr. Brock said, and I've heard this argument, that there's no provision either really in our zoning ordinance or in state law for a review. There's a provision for renewal, and there's a provision for revocation. But what exactly does review mean? Does it mean if they don't? I mean, let's just take a hypothetical and not this. Let's say somebody got a special use or a special exception permit to build a Marriott courtyard right here in town, right on the outside of town, so to be the county. And the board passed it subject to review in 5 years because a lot of the neighbors said, oh, you know, there's going to be a lot of noise and traffic and headlights and people calling the police and it'll mess up the neighborhood. So they said, okay, we'll have a review in 5 years. Does that mean that they could 5 years down the road after they've spent who knows how much building the motel say, well, everybody's just as mad now as they were back then and it's even worse. So, based on our review, we're terminating your permit, even though you've complied with all the conditions we put on you about the hours of operation and how many parking spaces you could have and screening and all that, setbacks, blah, blah, blah. We did all that, but everybody still hates it, so we're terminating. Could they do that?
Well, I think if we were in court, Mr. Lockerbie or Mr. Goff would be the first to say, if they were challenged on that, they would be the first to say that the board has broad legislative discretion.
Who does?
The Board of Supervisors has broad legislative discretion to make legislative decisions about land use entitlement cases, subject to a couple things, coupled to conformance with procedural defects, and also not being arbitrary and capricious. And so, if that were appealed to circuit court, that determination, then that would be the standard of review, whether this decision, the reasonableness of that decision was fairly debatable. And so it's a very low bar that the local government has to pass. But the case that you cite might be one that would pass.
But my question is not really about the reasonableness standard. My question is about, wouldn't they come in and argue they had a vested right? You gave us a right, and the word that you made up, review,
Well,
you should have said, if you wanted to do what it is you're saying you want to do, and essentially what you're saying the board did in 2012, then the board should have put in the word, it's subject to renewal in 5 years. And then it would clearly expire, and they would have to come back and jump through whatever flaming hoops they had to jump through.
I think the difference in that scenario would be that you described the hotel, the motel, whatever it is.
Right?
Under your scenario was a lawful use from the start, that it fell within the definition of hotel. And that the landowner reasonably relied upon that approval and probably would have a pretty good argument that it had vested rights. The distinction here is that the use was not lawful from the beginning. And under the cases that I've cited, you cannot have vested rights in an unlawful use.
And what exactly are you saying is the unlawful use?
It does not fall within the definition under the zoning ordinance of contractor's office.
Well, what doesn't? What part of it doesn't?
It's a snow removal, a tree removal, a tree storage, wood chip storage. The definition of that is,
Okay.
stated, I have some somewhere. Let me see if I get it. The definitions from the zoning ordinance of a contractor's offices, shops, and material storage yard, establishments for the construction and/or repair of buildings, roads, and utility lines, installation and servicing of heating, cooling, and electrical equipment, flooring, painting, plumbing, roofing, and tiling, and/or excavating. The use that was approved as shown on the permit in 2007 related to snow removal, tree removal, and that sort of thing. And plainly, when you go out there, you don't see any of the things that are here. So we're going to have testimony today and pictures that are in your package about what is actually occurring out there. The board, but the Board of Supervisors had no authority to approve a use under this definition that it didn't fit. And the board, the silver lining in this for the landowner is that the Board of Supervisors has plenary authority to rewrite this definition. It can rewrite this definition subject to public hearings before the Planning Commission and the Board of Supervisors to conform with what Mr. Williams is doing. And that's what should happen if the legislative will is there. But we submit to you that the legislative will should not be there, because what you have in this use is essentially an industrial use in an agricultural zone. And that's why it wasn't legislated in the first place. It was not legislated in the first place because the Board of Supervisors didn't want that use in this zone, but for some inexplicable reason, in 2007, the Board of Supervisors passed a special permit for a use that doesn't exist in the zoning ordinance.
Well, what about...
And nobody challenged it.
Let's let him finish his case.
Thank you.
Thank you.
So, we're going to talk about, I think we have talked about vested rights, and we've talked about the 5-year review. We also think that the zoning administrator letter is wrong to conclude essentially that there has been no expansion of this use and also no violation of conditions that are set forth in the minutes from the 2007 meeting that we discussed earlier. First, we need to address standing, and as stated in our papers, the appellant's property is only one property removed from the subject property, and they have standing, as they will demonstrate here in a minute, because they can easily see and hear the impacts of this use from their property. And also, although not necessary, they also have a different driving experience of Benview, the new road, for 2 reasons. One, because they have to go down the road every day to get in and out of their property, and also because they have to cross against the trucks that are on Benview New Road. I'm going to show you a statement, a photograph that is also in our supplemental statement. I have copies for the board, and I'm going to ask Patty to come up here and testify if she would.
Isn't that in our papers?
It is. I'm just trying to make it easier for you.
Thank you, sir.
Do we need some more stuff?
It's supposed to be up on the screen.
Okay.
I think we thought it would be up on the screen, but.
Let's just go.
What page is it? We can do that.
It's the exhibit A to our December 19, I believe it is, supplemental statement.
Can you find it?
Can you punch that up there? Try to make everybody.
It should be a long for me to go through.
It's our December 19 statement, on that one.
You all turn around, guys.
It is not that big pack.
It's not a full package.
Okay, I'm just.
All right, we don't have it on the same stuff.
Is she gonna testify on that?
Yes.
Okay, you swear to tell the truth, the whole truth, and
I do.
Okay.
and you can identify yourself.
Sorry?
Would you identify yourself?
Oh,
just for-
I'm Patricia Hardy,
And Ms. Hardy, where do you live?
423 Benvenue Road in Flintville.
All right, and where is in that relation to the Williams Woodyard?
It's one property over.
All right, now looking at this photograph, the Board of Zoning Appeals has copies of it, and it's also in a record. And it's called Exhibit A, and it's Exhibit A to our December 19 supplemental filing. Would you explain for the board where your property is in relation to the Williams property with reference to these labels that you put on?
Right, well, you can see where I've marked the Hardy Freitag residence and circled it. It sort of shows, but I think you can see it. It's where the blue dot is, because that's where it was on Google Earth. And then I show the property line between our place and the Williams Orchard, and then the Williams Tree Service is right there. So essentially, it's sort of, it's hard to tell the orchard from the tree service because it's all Williams property.
I have a quick question before we carry forward. Are we willing to make a finding that they have standing? Is that, Art, do you?
Mr. Chairman, maybe we should wait until all the parties have made their arguments and have the public hearing, so the public has their...
How long will it take?
Okay, not going to take too long. So Ms. Hardy, looking at the photographs in the state in the package, and at page 46 to 50, direct the board to take the photographs from 46 to 50. Can you tell me what these photographs show?
These photographs were taken from our property looking toward the Williams Tree Service, and you can see the stacks of wood back there.
That's number 46, I believe. Hard to see the number
On mine, these photos aren't numbers.
But you're on the right ones.
Remember,
It's
they're just-
between that
the numbers
versus-
continue.
It's on my property.
Yeah, it's after 46, and the next one is probably...
Okay, well, this is in the record, so 40,
There's a-
047 has a little bit of red down in the corner, like the
Yes.
top of the tractor that's in the next picture?
Yes.
Yeah,
Correct.
Okay, great. So that's 48, we're on there.
48 is the red.
The picture of
48 is the tractor.
And that's
Right.
again looking toward the Williams Tree Service, and you can see some of the operation in the back.
And the next one,
Yeah, this also was taken from our property looking toward the Williams Tree Service, and you can really see the logs there. So this is what we see from our property.
okay, and then the next one?
The next one is the same thing, looking toward that same area, and you see the stacks of logs in the back.
And are these fair and accurate representations of the view from your property?
Yes.
And where about on your property are these pictures taken?
Sort of between that garage, near the garage and the vineyard fence.
Okay. And so is it a fair characterization of your testimony that you can see the logs and the wood on Williams' property?
Yes, sir.
What else can you see, if anything?
Well, I mean, we see trucks. You can't really see it on here, I don't think, but I mean, we do have pictures of trucks coming and going and being on that property.
What, if anything, can you hear from your property?
Well, we hear beeping, we hear sawing, we hear machinery working, we hear like the beeping of trucks coming and going.
Tell me, how often do you travel Benvenue Road?
Several times a day.
And is it fair to say you have to travel that road to get to your property?
Yes, to get to the grocery store, to get to anything.
What do you see any trucks on the road when you're traveling?
Frequently, yes.
I'm going to ask the board to turn to pages 68 through 73 of the packet.
What is that?
What pages?
68 to 73.
2018 truck pictures?
Right, 118 truck pictures. And ask you if you could thumb through these pictures and ask me if you recognize them.
Yes, I mean, these are taken from the road, this is the first, well, they're all taken from the road looking towards Williams. The first one is, well, you can see the size of that truck, that huge, I guess it's a delivery truck. The next page is again, looking from the road toward the property. You see the piles of wood, and there's a great big 18-wheeler truck there.
Excuse me 1 second, Mr. Hampton. Did you take these pictures yourself, or did somebody else take them?
I've taken one or two, and then there were some others taken by the other neighbors.
Are they fair and accurate representations of what you see on your property?
Yes. Well, from driving.
Just a second.
Yeah.
Hold on a second.
Pardon?
Counsel?
Sir.
My view, she can really authenticate the pictures that she took. I mean, if they want to put them in, I assume they're going to move them into the record.
That's not the evidence.
What?
That's not the evidence, law, evidence as I understand it. Someone doesn't have to take a picture to testify that they're fair and accurate representation.
She can't testify of what date it was taken,
I think
unless she was there. I mean, that's my question. Did you either take it or were you present when they were taken?
One of them,
Which one?
the very last one. You see there's a double logging truck right in the middle, and a red Kubota tractor off to the side.
And there's like a box in the...
Yeah, there's a box in the front.
All right.
yes.
Okay. And is that a fair and accurate representation of what you saw the day you took that photograph?
Yes, if anything, it was worse than the photograph was.
And what day was that picture taken?
Oh, geez, it was taken, I don't know, but it was taken sometime in the last few months.
Yeah, because it's winter.
I mean, I can look on my phone, I suppose.
You notice the leaves are off the tree.
Right,
Yeah,
right.
winter.
All right.
Well,
I think
that's
that's all I
maybe not.
I have.
Okay, that's fine.
Well, who is the judge? The
But
board
it
is the judge, right?
But I would say in an administrative body, you can vote if you would like to reject a piece of evidence. I would suggest that probably the better course of action is to let the lack of authentication go to wait.
Okay. I agree with that.
All right, thank you. Mr. Freitag? I just want to give you the opportunity you've heard, Ms.
So Bill, do you identify yourself?
Bill Freitag?
You swear to tell the truth, the whole truth?
I do.
I just want to give you the opportunity to, since you listened to Ms. Hardy, who is your wife, correct?
Right.
And give her testimony, and do you have anything to add about what can be seen or heard from your property?
Not really. I can only add to it that, yes, we can hear the equipment being used, the chainsaws particularly, and very frequently starting well before daylight and continuing on well beyond dusk. And I think I can only add to what she said about our need to use the road, which is obviously different from all the other citizens in our county who don't have to drive 729 to get out of their property. So we are, I think, definitely impacted by having those trucks. And I think we've talked enough about what 729 is all about in terms of traffic problems. I should have brought my molten aluminum from one of the car wrecks on our road that we all seem to have experiences with traffic problems on that road. And
So you said that before dawn, similarly before dawn and then after dusk, the machines or the loud machines are going. So, because it says that the hours of operation are between 7 a.m. and 7 p.m. So you're saying they start before 7 a.m. and they go longer?
it depends on what time of the year it is.
Yeah, I mean, because right now, I said they'd be working in some dark, you know, but, so something like a dusk to dawn, a dawn to dusk would be better, that way you wouldn't be asleep.
Yes.
Anyway, I just. And weekends too.
What time does the noise start in the morning?
At this time of the year, it starts about, I don't know, 6:30 to 7.
Okay. And it goes on
As a matter of fact,
weekends
it's dark enough that this morning there was a large truck, it looked like a logging truck, roaring by our property at 6:45. It was dark enough, I couldn't see the truck except for its running lights. And the lights carried for 10 to 15 meters after the cab went by.
Okay.
So I know it was a long truck. Now, I'm not saying that that was a Williams issue, but it is part of the issue of the road being just a really dangerous place to be.
And
Thank you, sir.
Okay.
Thank you.
oh, that was the other question, and even this is on the weekends too?
On many a Sunday, I hear the saws going.
Was there restriction for the weekend, not on weekends? It just says 7A, 7 to 6P. It doesn't, I don't see in here where it said something about no work on weekends, unless it was snow operations or something.
That'd be another stupid decision somebody made, right?
Okay, so based on this testimony, members of the Board of Zoning Appeals,
Stupid.
we submit that the appellants have standing. They have demonstrated that they can see the use, they can hear the use, and they experience it in a different way from the public generally. And therefore, we contend that the board should find that they have standing to bring this appeal. We've already really pretty much covered the second point that I was going to make in my colloquies with Mr. Connick and others, that with respect to vested rights, I'll just summarize it just very briefly. And that is, the crux of our case is that the use does not fall within the definition of contractor offices, shops, and material storage yards. And this point was raised by Mr. Mann in his letter of October 14 on behalf of himself and the Denver new residents. The definition I read to you before, it relates to the construction and repair of buildings, roads, utility lines, installation, servicing of heating, cooling, and electrical equipment, flooring, plumbing, roofing and tiling, and/or excavating. This use is none of those things, as the testimony will show, and as I don't think that's really contested, that this woodyard use does not fall within that definition. Again, the board has no authority to legislate a use that does not, that its own ordinance does not allow, and therefore that use cannot be allowed, and the zoning administrator's letter is incorrect to the extent it says that it doesn't matter whether it falls within that definition. It does matter whether it falls in that definition, and the Board of Zoning Appeals should so find. The consequence of that is that it's void ab initio, but we are not asking the Board of Zoning Appeals to make that determination. That would be for another day in an appropriate forum. Again, the vested rights, we talked at length about vested rights, and I've set forth my argument as to why that does not apply. It applies only to a use that is legal in the first place. This is not, because it doesn't fall within the definition. And it only applies to a subsequent legislative act. We do not have that in this case. And by the way, this board has no authority to legislate anyway. This is clearly a quasi-judicial board. The third point we've already discussed briefly. I'll summarize it. The zoning administrator's letter validating the use, she says that it's valid in compliance with conditions. She has no authority to so rule because the Board of Supervisors has legislated that it must be reviewed. Whatever the board meant by that, and I admit that that may be a subject to some determination, but I think it's appropriate to let the Board of Supervisors make that determination. And by the way, it did in October 1, 2012, as reflected in the minutes, namely a full public hearing and a determination that the use is appropriate with some modifications to the conditions. That's what happened. That's what should happen. That's what should have happened in 2018. But as I say in my materials, for some reason when we get to, and this is footnote 2 of page 5 of the original appeal packet, Exhibit F, there was no review. There was merely a discussion on September 5 and direction to the zoning administrator to go out and check the place and check it out. That is not a review, and indeed, if you look at those minutes, you will see that Mr. Curry took issue with the term review, said it wasn't a proper term, and that seems to have dissuaded the board from going further and actually doing a review. But I will submit to you, just as Mr. McCarthy can't legislate a use, just as the zoning administrator can't legislate a use, Mr. Curry could not legislate the term review out of the board's ordinance. So if the board wants to change that term, modify that term, that's up to the Board of Supervisors, not to administrative officials.
Just a sec, I'll ask a question about that.
Yeah.
What are you saying? I mean, I understand you're saying in 2017, when the second 5 years was up, they either didn't do any review, or they didn't finish the review, or they didn't have a public hearing like they did, whatever they didn't do.
Right.
I guess I'm going to ask the rhetorical question, so what? What is the impact of that, legally, in your opinion? Do you think that that terminates the permit?
He's suggesting.
Well, wait a minute, I want to hear what he says, not what you say. I know what you're going to say.
I've said in my papers that the permit is lapses because of that. But I also think that...
So you're equating review with renewal?
Well, let me finish. So beyond that, as I say I also say in our filings, and I'm saying to you now, the zoning administrator, we're getting back to what we're here for, which is the November 5 letter, in response to Mr. Mann's October letter, says that the use is in conformance with the conditions and has not been expanded. What I say to you on that is that the zoning administrator, being an administrative official, has no authority to do that when the Board of Supervisors has not done that pursuant to its own ordinance. That the Board of Supervisors is the one that needs to conduct that review and determine whether it's in compliance with the conditions. That review cannot be superseded or circumvented by an administrative official under the cases that I cite, namely that a zoning administrator cannot legislate. That's what we're saying. So that those words have meaning. If there's some issue about what review means, then the Board of Supervisors is the one that needs to explain that. But I would suggest to the Board of Supervisors, if I were speaking to them, that they've already determined what it is, namely a full review a la October 2012, as is reflected in the minutes. And so our final point is that the zoning administrator is wrong, getting back again to what we're here for, the November 5 letter, the zoning administrator is wrong that the use is not expanded. And in this regard, as Ms. Matthews has identified, I think the critical document is on page 22 of the package, which is the 2007 minutes, which contain 12 conditions that were modified in 2012 in some respects, which we'll talk about. And to see what those are, you need to look at pages 28 through 32 of the package, but most specifically page 28. Page 28 is the August 30, 2012 memorandum from Mr. McCarthy stating what he was going to suggest to the Board of Supervisors in terms of a modification to the 2007 permit. And in our original appeal package, you will see that that he also said later that these recommendations were followed. So what you need to do then is to look at the various conditions on page 22, as Ms. Matthews has already done, and note that on page 28, the number of employees was reduced to 7 on page 28. Excuse me. 3. Okay, 3, excuse me, 3. I didn't say that.
3 employees.
3
It
employees.
went from 7 down to 3.
Yeah.
Four down.
Okay. That the hours, that the farm tractors were added, and that condition 3A was modified in some respects.
Mr. Hampshire, isn't the reason that you're talking about exactly now, that they amended the permit, isn't that the reason that it had to go to a public hearing? Because they amended the conditions, right?
They went, well, you're right, well.
So when they amended the permit under 15.2, help me out here,
2204.
2204, thank you, council, they had to give public notice that they were going to amend the permit conditions. But in this last year, 2017 or 18 or whenever they were supposed to do it, if there wasn't any amendment, where do you see in the word review the requirement that they have another public hearing?
Well, we don't know whether they would amend it. I mean, that's the whole point. We need to have.
But if they had amended it, it would have been illegal if they didn't give notice.
Well, right, and that's why you would have notice, because of the possibility of amending the permit.
But in the 170-58 of Rappahannock County Code, it does talk about the zoning administrator shall inspect the use, review the applicant's record of compliance with those conditions, standards, and restrictions previously imposed by the board or the BZA, and make a determination on whether the special permit or exception use still satisfies the applicable standards of the chapter. And the zoning administrator shall also notify the appropriate approving authority that the request has been filed. And then it goes on that they're...
For extension.
And then so upon favorable finding, the zoning administrator shall issue an extension of the special use, of the special permit or the special exception for the period of a time that may be specified in a particular category.
But this isn't an extension. This is a permit without any limitation. There's no time limit.
Is it 2012?
Any of them.
2007.
It was a review.
It was a review, it wasn't a termination, it didn't have a term that had expired.
Okay,
We'll get to that later.
Okay, go ahead. Do you have anything else?
Well, so, yes, so what we want to do here, and I'm going to call some witnesses here to go through these conditions, a couple of them, and we will prove that these conditions have been violated. So again, the conditions we're going to talk about, condition 1, the hours of operation, we've talked about that a little bit already. Condition 3, the material storage, it's already been testified that the firewood and logs are stored too close. The number of employees, condition 9, are exceeded. And the number 11, the number of 2-ton trucks are, the weight of those 2-ton trucks has been exceeded. So what I'd like to do is to call Ann McLean up to the stand here. And
Before
ask
you
her-
do that, Mr. Hampshire, Mr. Chairman, I have a point of order, or at least I like to ask council a question, and that is this. We're sitting here as a board, as I appreciate it, to rule on whether or not the zoning administrator made a proper or an incorrect determination on whatever day she made it. It's November 14, the 5th, 2018. Okay.
Well, the letter is...
Well, whatever the date of her letter is, we're here to make, as I appreciate it, our jurisdiction is to determine if her decision on that date was right or wrong. And I have a question about witnesses or evidence that they're trying to put in to bring it directly to the board and say, oh, look, this is what we saw, but it's not in this letter. You know, and the pictures aren't in this letter. And so if they're going to start putting in stuff or testimony and evidence that goes beyond what they submitted to the zoning administrator, my point of order, my question to you is, are we supposed to consider that? And if that's not part and parcel of what they submitted to the zoning administrator when they filed this Bob Mann letter?
It is what happened.
Now, I do have one question. Well, let me ask a quick follow-up. The question is, there is no time limit on whether they're in violation. I mean, they could be found to be in violation tomorrow, regardless of what Michelle.
But we can't make that finding, only she can. That's my understanding.
Or the board of supervisors could.
Okay, but we're not them, so.
But what I'm saying is, there's no timeliness of are you in violation.
No.
She determined they're in violation of or a certain part of it, but not others on a certain day.
Right, and that's all that's before us, in
And
my
so
opinion. That's my question.
the other evidence that we could go on for an hour proving that they were in violation at some other point in time.
Like this morning.
Or when the truck started and all that. But that, her ruling does not mean that they can never be in violation again. They could be shown to be in violation. I'm not sure that what the benefit is in us making that determination.
Well, if you look at the November 5 letter, you'll see point number 2 is that the...
Just a second, we'll get back.
Is that all?
And when you're ready. It's in the original appeal packet, this is Exhibit A, the original appeal packet.
This is the answer. Where's Bob Mann's actual letter?
It's on page 2.
Page 2?
It's 2
Of the big thing?
On the big book.
Got it. Thank you.
It's in the original, it's Exhibit A. And she's responding to Mr. Mann,
Right.
right? And she's saying, you, Mr. Mann, have stated that the intensity of use has increased since this SE permit was issued, causing a violation of RCC section 170-B, 50B, etc. And then she goes on to say that the board has placed conditions on these permits for certain things, and that there were no conditions set by the board that would limit the number of piles and stacks of height. Now, we say in our papers that that is a non sequitur, because just because there are conditions that say it can't be expanded doesn't mean it can't be expanded. So our evidence is going to show, in addition to the violation of conditions, that the use has been expanded, and that is relevant to whether or not the use is within the original permit.
Well,
And
then you didn't
so
understand what
far-
I said, and I council did, so I would like an answer. For example, I mean, I'm looking at page 003. And the third full paragraph, it says, "The county has been informed of many of these violations on multiple occasions, and yet no action has been taken. And indeed, the staff has misrepresented to the Board of Supervisors that no violations exist." So, you know,
Are there any documentation on any of these violations?
Well, that's what we're
Yes,
trying to show
if you
you.
let us talk, yeah.
He's going to call.
well, I don't know if you're gonna call or not, but my question to council is, can we go outside the four corners of what's in the original complaint and the four corners of the zoning administrator's answer to that? By hearing evidence that wasn't submitted to the zoning administrator, or looking at photographs that weren't submitted to the zoning administrator.
I think that you can. I think also, however, that there's a certain amount that goes to, again, that goes to the weight. a picture that was taken a week ago might or might not have much bearing in your mind on what was going on whatever, November 15th. So I'd let that matter go to waste.
So do you wish to call?
I do.
Thank you.
And
You want to identify yourself?
Sure, I'm Ann McLean.
You swear to tell
Wakefield.
the truth, the whole truth, and nothing but the truth.
Absolutely. Okay. 392 Benvenue Road.
and where is that in relation to the property?
We live kitty corner to the orchard.
Is it on here?
Yes, I'm sure there's,
Can you
I haven't actually seen this.
Hold that up and sort of point?
Sure. In relation to the Patty Harvey, they're across the street. Strangely, I don't, is this,
It's the old Shershell property.
okay.
Where it says Skyline hot air balloon?
No, well before that,
What
we're
do you mean
much
by
closer.
before?
Well,
Like
because
closer to the
we're much
right?
closer to the Williams.
Probably in.
I am across the street, but when I cross the street, I have to, if I'm coming out of my driveway, I have to either choose to walk straight and hit the Williams orchard or go slightly right and hit their vineyard.
So you don't see your own house on here?
Strangely, I guess I do. It's
Just don't recognize?
it's closer, it's even closer than Patty's. It's, like if this is the big circle where the Williams Tree Service operates, we're across the road, but
Okay.
closer to it.
Okay, got it.
Okay.
All right, I want to direct your attention to the photographs that are on pages 55 through 51 through 55 in the packet. And they're right here, and for the board, we're looking at
Mainly 52.
52.
I was hoping to talk about several of them, but
All right.
one is 52 versus 57.
Here you go, you're right.
Okay, I didn't know them
All
by
right,
heart.
all right. So tell me about 52 then.
So 52 was taken in 2010,
By you?
I believe by Patty Hardy, actually.
I'm sorry.
I'm
sorry, which
Sent them
page?
to me. It's in page 52.
Oh, yeah, the 2010 photos are from the file in the zoning administrator's office.
We've submitted them to the Board of Supervisors before. Okay, and then I was gonna sort of talk about the difference in it between number 57, which has the same angle, so I just thought it was good for comparison purposes. But if I may, I would like to discuss tonight the clear violation of Code 17050B, that is, that the use shall not be enlarged, extended, or increased in intensity. In response to Ms. Summers' November 5th letter, in which she states that she does not believe the intensity has increased to the extent that would trigger a violation of this particular code. So I was, in these two pictures, trying to show, appeal to your good common sense. I'm not a lawyer, but even, I can figure out that at least for the first point, that if you want to say it should not be enlarged, I think we can pretty much show that at least on number 57, that's the same exact angle from the same part of the driveway across the street.
So you're comparing 52 to
52 to 57, I just happen to think they're clearest comparison because they happen to be from the same angle. So I was just appealing to your good sense there that looks to me like an enlargement. And it was also left out for some reason of your document tonight, but Mr. Mann did include it. It was in, to answer Mr. Connick's point about her, Ms. Summers' November 5th letter was in response to Mr. Mann's October 14th. These two pictures were submitted in the October 14th letter as a before and after shot. So I definitely think that they're pretty good to be able to use. Anyway, so I'm just saying, looking at those two, how can you say that there's been no enlargement? And then to show you just the sheer size of what the see every day when we pass here is, you could turn to page 70, which has a picture of, I took this picture on page 70 myself, and what,
Wait a second.
sure, there it is. It's just a picture of a large truck. This particular, if you could look at the truck mainly, actually. This truck is Williams, it's in the Williams fleet. It says Williams Tree Service on the side, so this particular 16 or 18 wheeler is actually within his fleet. Anyway, I wanted to note, and I wanted to show you all, if you'll accept it, the picture that I took just seconds before this one, because that same truck that's about 16 wheeler in this picture looks like a little Tonka truck. And this is the same exact truck seconds before that I took that picture. So it didn't, this particular picture did not make it into the 103-page document that you have, but I felt it was compelling
when did
to
you take
show.
this?
The same exact date, oh gosh, like what date? Did I take it? It was definitely this year, and,
2018.
oh, sorry,
In the
I'm in
fall.
2018 still.
Late summer.
Yeah, I just thought it was compelling to show the sheer size of the wood. It makes that 16 or 18 wheeler look like a little Tonka truck. You can't even see it in the, if you can find it in the picture, it's the same one as that huge truck. And I thought it was a compelling shot as to how big. So if I can just appeal to your good sense and your reason, I think that that should prove that this has been enlarged. Now, there are 3 parts to this code. One, that the use shall not be enlarged, which I hope that I just proved. The other is extended, and then the third, I wanted to talk about the increase in intensity, which I have just a record of violations, permit violations as well. So as far as not being extended, in section 3.A of the Williams Tree Service permit, it states that firewood and logs may be stored on the premises at least 50, and then in 2012 it was changed to 25 feet from any property line or road. Until Ms. Summers' notice of violation, the logs were in violation of this setback against the public road, but they remain in violation from property lines. If you look at the plat on page 8 of I guess Mr. Williams' property, in conjunction with the picture on page 61, you may be able to see that it's definitely not 25 feet from the property lines. So I just feel like in the November 5th letter that we are trying to appeal and get you all to say that, that there were some mistakes. Ms. Summers didn't actually fully look at the setbacks, which were in Mr. Mann's October 14th letter to ask her to please look at the setbacks when she was on the property.
So you feel that she, from the road?
She did a great job with the road. She wrote a violation, and Mr. Williams actually
But
fixed
didn't
it.
do the whole perimeter?
As far as I'm reading his permit, it says any property line or public road. So when we had asked for a setback, maybe she, that's just one of the things that I would say is a clear violation of Code 17050B, which says that you can't enlarge, which I think I just showed, extend, which I think is the reason for the plat here, and increase, which it's my next point, if I could just make it.
That's fine.
Make the third point.
Go ahead.
So third and last point. Under this code, it says the use shall not be enlarged. I hope I showed that. Extended, I hope I showed that. And now I really want to talk about increase. In the conditions for the Williams Tree Service permit, it states that there can be, quote, not more than 3 persons employed on the site. This is a daily violation. Since our accounting began in October of last year, I guess 2018, there's copies for everybody here. This is really just 17 days in a matter of 3 months that we started accounting, but really it's a daily thing. Ms. Summers was notified in writing of this violation. So the Board of Supervisors has been told in writing about the violation also in the permit, which was not addressed at all actually in the.
Was this put in with Mr. Mann's letter?
It was not. If you'll note, Mr. Mann's letter was October 14th and the first date on there is October 16th.
My question is, what, you said that this has been given to the Board of Supervisors.
Well,
They haven't done anything about it, but.
no, I just am saying that in the November 5th letter that you all are looking at, she Ms. Summers stated that she does not believe the intensity has increased to the extent that would trigger a
Okay,
violation.
but you didn't give this
She
to her.
had not seen that,
Okay.
but she has been notified in writing of this.
So, I want to.
Do you
Okay.
consider yourself an appellant in this case?
Well, she's a
Yes.
she's a witness.
I actually do. I think all of us do. Now, I realize that, again, I'm not a lawyer and you can argue over who was written on the letter, but in the October 14th letter that Mr. Mann wrote, he named all of us, every single one that has been named tonight by Mr.
She's functioning as a witness, Regina.
So then she should just testify as a witness.
Well, we hear it 7 days a week, and, some other things that weren't addressed were in 17053 that Mr. Connick, you tonight said that applies to all SEPs, and one of them is sound limitations for peaceful enjoyment of neighbors. So I think that I'm aggrieved. Anyway, that was it.
But if you think that you're aggrieved, why didn't you appeal?
We've all actually sought the counsel of Mr.
Well, then why aren't you listed as appellant?
That was a litigation decision, so.
I didn't ask you, I asked her.
I don't know. I consider myself one, for sure.
You
We
do,
don't
but not on the papers.
That's not our issue.
Members of the BZA, Ms. McLean is testifying as a witness
Yeah.
in support of the appellants.
Well, then she doesn't have to demonstrate standing or tell us about her standing.
You're the
She's not
one
an appellant.
You asked me if I felt like an appellant, and I said I do. But I'm also, I've said several times I'm not a lawyer, and I'm just trying to appeal to your good
Okay,
sense.
well, let's move on.
Right.
Okay.
Okay,
Thank
thank you.
Thank you.
Next, I'd like to call Mr. Mann, please.
The one thing that I would want to know, Mr. Connick, is that she could talk for 3 minutes at the public hearing anyway, so.
I don't have a problem with her talking, I just, she's gonna have to prove standing is all I'm saying. If she's not,
She's not on the paper.
unless she's gonna testify about what the appellants.
Can you identify,
Yeah, go ahead.
can you identify yourself?
I think so. My name is Bob Mann.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Mr. Mann, what's your address?
490 Benjamin Road.
And directing you to condition, are you familiar with condition number 11 of the permit in this case? I'm referring to page 23 of the package. Where it says there should be no more than 20 self-propelled vehicles located on the property with not more than 10 tagged. Of the latter, the maximum size shall not be more than 2 tons.
Correct. I can read that.
And you had the opportunity to observe the property and the end runs around Benjamin Road.
Yes, I have.
Can you show us on this exhibit where your place is?
Oh, it's off that chart. I'm down the road.
Which, the right or the left?
Toward Flint Hill.
Good enough.
All right. What have you, when you tell the BZA what you observed about the size of the trucks?
I understand that the limit in the SEC is 2 tons.
The what?
Special exception.
Oh,
The special exception permit is 2 tons. So what we have there and what the US and the federal law state is a 2-ton truck is really a 2-ton capacity truck, carrying capacity. Typically light-duty truck, anything up to 10,000 pounds. Okay? So that's your smaller size pickups, things like that. Once you get above 10,000 pounds, and it's very easy to do that, total gross weight, okay? You're over the limit. And most of the vehicles, most of the trucks that you've seen here that are in that property are over that limit. Okay, every time we go by, every time I see it, there they are. There are smaller pickups, okay? They could possibly be less than 10,000 pounds with full load. But you've got to recognize a cord of wood, a dry cord of wood is about 1.5 tons minimum. Can be more if it's heavier wood. So we're talking about a violation of the 2-ton trucks. I've seen it for years. The trucks get me into being on the road. Being on the road gets me to feel aggrieved and I'm a half mile away. Why? Because I have to go and drive that road to get to my house. There's no other way. I don't have a helicopter, I can't come in that way. And these trucks are on the road, the big ones, the small ones, and some of them are Williams trucks, some of them are not. Some of them are cut-through trucks. We're dealing with that separately, but we still have the Williams trucks to deal with. And those are issues. I've been forced over on the side of the road several times with a couple of these trucks. And I don't like it, nobody likes it. So I believe that anybody that's on that road, that lives on that road, has got to feel uncomfortable driving on that road with the Williams trucks on the road. And some of them are big. Some of them are really big. So that's an issue. That's a safety issue. That safety issue is something that the codes talk about. The proposed use shall be such that pedestrians and vehicular traffic generated will not be hazardous or conflict with the existing or the anticipated traffic in the neighborhood or on the streets serving the site. This is significant. And it's a significant thing to my family and I think to the people who live on that road. We can't get to our houses any other way, or we would. The cut-through people, well, that's their choice to move that way. I'd like them off the road too, because they're the ones that are living. But safety's an issue, and safety, they're in violation, if you look at the codes, they're in violation if we believe that that's a real safety problem on the road, and I certainly do, and I think our neighbors do. We've already heard about, from Ann about the expansion. The codes are very clear about that, about how much you can expand or can expand. Chapter 170-50, status of special uses, says enlargement states, once a special permit or special exception has been granted, the use shall not be enlarged, expanded, or increased in intensity or relocated unless an application is made with a new special permit or exception. And you've seen some of the pictures and the differences there. I would have thought that that would have qualified to be a problem and to something that would be something that would really be cited by the board and the zoning administration. And the third one I want to get into is briefly, if I may, is the issue with regard to some of the local neighbors. The issue, a requirement and a condition of the SEP is that the location, the size, the heights, the structures, and all that stuff doesn't adversely affect the values of the property. Right? No value depreciation because they're right across the street. There's two houses directly across the street. I don't know who lives in each of them. They're not here tonight, I don't believe. Each house is well over $1 million. Right? I had an appraisal of my house done this weekend. Not for anything to do with this, I just needed it for estate purposes. And I asked the guy, I said, come down here and take a look at this. And I said, see what you see here? How do you think it affects those houses up there? He says, 5 to 10, 12, 14%. He says, because it's in their view shed, they can see it. You're going to buy a house like that for the view. And when you have this in the view shed, it's an eyesore. So is it 5, is it 6, is it 8? I don't know. Is it 10? If it's 10, it's a $100,000.
I don't think this relates to violations, does it?
Yes, it does. It says right here. Here you want to go? Here we go. Here.
No, but the
Article-
value of the.
It is a violation, and we talked about it in the list.
Absolutely.
Chapter 170-52, general standards. The location, size, height, building, structures, walls, fences, and the nature and extent of screening, buffering, and landscaping shall be such that it will not hinder or discourage the appropriate development and or use of adjacent or nearby land and or buildings or impair the value thereof. There.
Okay, we know it's in the ordinance. I have a question for
All right,
you.
but I don't think that we're governing to that. Excuse me, sorry. Go ahead.
I'd like to turn your attention to page 39 of your own filing. And it's a letter from the former mayor of the town of Washington, John Fox Sullivan. And he says in the third paragraph, secondly, it's about the fourth line, secondly, I find the woodpile and general look of the place not only consistent with the nature of our agriculturally based county, but also attractive and appropriate.
In
6
2012.
years ago, and he doesn't live near us.
And this is
Oh,
2012. This is 2012.
I understand that.
Look at the pictures of 2012.
I'm just asking you a question.
Okay,
That's a matter of opinion.
That's an opinion, that's exactly right,
Okay.
that's an opinion.
However,
However.
That's his opinion, and
However-
your estate
Okay.
appraiser has
No,
her
we've got
opinion.
four inputs on that. and
Okay.
that was just
Mr.
one.
Chairman, I would like to suggest that we are losing control of this meeting and that we need to give the people who are testifying and giving witness a chance to give their witness so that the opposition can at some point give their opinion.
Sure.
And it seems to me that constantly cross-examining witnesses as they are testifying is going to make this meeting undoable.
Well, I'm very sorry, Mr. Chairman and Mr. Byrd, but that's the purpose of a hearing. They've got witnesses, and we're supposed, it says right in our rules, the members of the board are allowed to question all the witnesses. And
Okay.
I'm just going by the rules.
why don't we just move this along?
All right, fine, we can move it
I'm
along.
done with this.
Fine with me, but
You'll be able to finish quickly?
Yes.
Okay.
I don't need somebody to read me what's in the ordinance either.
I have a valid question that I would like to ask, and that there are claims on road safety and Williams trucks. Are there recorded incidents of accidents involving his trucks on that roadway?
I'm not aware of any.
Do we want to call back the witness and so that the witness can testify as to his
Do you
knowledge
have-
of accidents?
Or maybe Mr. Rivers?
Well, there are accidents on the road, there's plenty of accidents, but I
But
can't say
none-
that they're involving the Williams trucks.
None that you know of?
Not that I know of.
Okay. Is that a fair answer?
That's fair answer.
I will point out that the relevance of the trucks is the 2-ton limit. And you've heard testimony that these trucks are much bigger than 2 tons, as best we can understand the term,
Well, a
Like-
pickup truck is a half-ton.
half-ton.
Not
And
necessarily.
Yes, a one.
It's probably.
We can't have going on in the audience.
if you look at the materials I submitted at the end, a Ford F-150 is half-ton, a Ford F-250 is 3/4 generally, a 350 is 1.
Right.
So we're talking about something bigger
So
than a 1 ton.
ton would
But
be
what the board has seen are trucks much, much bigger than that.
Okay,
And so that's the relevance of the truck testimony.
okay.
And I'd like to call Ms. McNally, Susie McNally, to stand.
Could you identify yourself?
Yes, I'm Susie McNally, Wakefield.
You swear to tell the truth, the whole truth, and nothing but the truth.
I've lived on Benton Road for 30 years.
Okay.
Can you show us on the picture where you live?
You can't see me.
Is it closer to Glen Hill or?
I'm on top of the mountain.
At the top of the mountain?
Ms. McNally, you understand any study of real estate values in the area surrounding Williamsville?
I have been told by a prominent local realtor, because I have a piece of property that has the big view, and 10% off.
10% off what?
For value,
Of the value of that.
because of the Williams operation. Okay.
And I have a letter from Jennifer Shishel, who grew up on Benvenue and who's lived there most of her life. She couldn't be here tonight, but she wanted me to read this
Well,
letter.
then just put it in the record. We can't read somebody else's letter.
All right. You can read it at the public hearing as well.
Okay.
Yeah, all right.
Okay, why don't we bring that forward, we can look
Put
at
it
it.
in the public record, all right. And so I think that's it. Yeah.
Okay.
Yeah, thank you.
Now, can you, is that
That leaves
enough?
this olive wood.
Is that enough witnesses?
I want to call one more, Lauren McGill. All right.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You can identify yourself.
I'm Lauren McGill. I live at 374 Benvenue Road. That's directly across the street from Mr. Williams' operation. And we run a farm across the street, and I am the farm manager, so I'm out most of the time outside. And so I can attest to the noise. There is beep, 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 beep. Oh my gosh. And there is click, 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 click.
That's the sound of the hay elevator raising all of these logs 20 or 30 feet up. There's the sound, there's banging and clanging of equipment. There are employees yelling at each other, trying to overdo the noise, as well as the diesel engines run all day long. More than a couple vehicles are over there. The diesel engines run, they rev, or they idle, they come and they go, but you've got that cloud of noise. And the icing on the cake in the noise department is the chainsaws. There's more than a couple chainsaws going. They go from sunup to sundown, and they go after sundown. And if you ask me how's that possible, I wondered the same thing myself. How am I still hearing all of that racket? I went and I looked, and they're working in the headlights. They have their equipment all facing whatever they're working on now. That's not every night. The sounds, the noise, the air pollution is every day. But the after hours does go on, and they make it happen. This is Monday, and this is every day of the week. They do not take a day off. They took Christmas Day off, and that was blissful. I thanked Jesus for the birthday because that was heavenly. There were birds. There's a creek bubbling. I heard things that I didn't realize other people in Rappahannock get to hear. I think we have vested rights in our property to have peaceful enjoyment of our property, and we don't get that because of the size of the operation. It's industrial. The size of the Williams operation is industrial, and we're not an industrial zoned area. We don't want to put Mr. Williams out of business. Our goal is not to see him go under or the employees to lose their job. But what we do want to do is put his business out of our neighborhood so that we may enjoy the luxury most other people have, is to just enjoy your life in Rappahannock County.
Thank you. I have a question. When did you move there?
A year ago.
Thank you.
All right, that concludes my witnesses. And just to sum up again, we urge the board to adopt the findings of fact and conclusions of law that I have submitted for the reasons that I've stated, namely that the zoning administrator is not correct, this use is protected by vested rights, and in that regard it does matter if the use is not allowed by the zoning ordinance. The use for that reason cannot be, that failing cannot be circumvented by reference to vested rights. We've also shown that that the zoning administrator may not substitute her judgment for the review that is required by the Board of Supervisors, and in her letter by saying that the use is in compliance with the conditions and has not expanded. Finally, our testimony has shown that there has been a clear expansion both under 17050 and for the reasons that have been talked about, and also a clear violation of conditions such as the hours of operation, the number of employees, and the size of the trucks. And therefore, we ask the boards of zoning appeals to reverse the zoning administrator's letter for the reasons stated in our proposed findings of fact and conclusions of law.
Thank you
very much.
Thank you. Mr. Reynolds, would you care to speak?
Thank you. Frank Reynolds, I represent Greg Williams and Williams Tree Service LLC. I was here in 2007, I was here in 2012, and I was at the 2018 to begin with, let me just say that 3 points that were raised in the letter that I submitted to you, and I ask that you consider those things. First of all, any appeal of this decision, which was made in 2007, should have been taken within 30 days, and it wasn't. I won't go into it. You've got your own counsel to tell you what all that means. Second, based on the 2007 decision, Williams Tree Service invested a lot of money, which is the part about the vesting statute, and to which to put forth his his business. Third, I believe that Mr. Freitag and Ms. Hardy, who certainly have opposed this for a long time, have not expressed any different type of opinion or any type of effect than suffered by anyone else who drives down 729, who lives on 729, or any of that. They have no more direct effect other than the conditions which were considered in 2007, which were hours of operation, trucks, noise, etc. All of that was considered then. There were limitations put on the chainsaws. As far as I know, there's never been a formal, I can find, never been a formal complaint that the hours of operation of the chainsaws were being abused and outside the conditions. We all know that depending on the time of year, whether it's after dark or before dark, it doesn't necessarily violate the conditions because it talks about time between a certain time and a certain time that the operations can be used. It doesn't say anything about dusk to dawn. It doesn't say anything about that. Now, let's go to another thing, the expansion or the enlargement of the intensity. When this permit was given in 2007, there weren't a whole lot of logs on that property at that moment. I don't think they're trying to say that, well, okay, well, you've got another truckload of logs, you've expanded the use. That's not what it meant. As I know, Mr. Connick knows, in terms of zoning law, expansion or enlargement of the use generally means you don't go to another piece of property. You don't take it to a larger area than what you've been permitted to do. Or the uses that are being done are exactly what he was permitted to do. So he hasn't intensified it, he's done what he was permitted to do. He hasn't enlarged it or extended it because if you look at the original permit and the conditions were generally, in looking at the requirements to be considered by the Board of Supervisors in their approval or rejection, were drawn by Mr. Williams to try to meet those conditions that the Board of Supervisors considered, because they knew that's what they had to consider. But when you look at that permit, there is no limitation in the number of logs or the height of the piles. Zero. So there hasn't been an expansion, it's been a conducting of the business. So that's just a red herring. Now, there's a lot been made of, I'm going to get to the contractor Jordan in a minute, there's a lot been made about these 2-ton trucks. Well, that's not quite the way the permit's written. And when you look at it, you're looking at John McCarthy's letter of July 3, 2007. I don't have a page number for you, but it accompanied the original permit.
What's the date on it?
It's July 3, 2007.
It's this one.
It's a letter.
No, that's not.
What's
Their
this?
letter. Just a second.
Or is it this one?
It's a relatively short letter, one page. And it talks about at their meeting July 3, Board of Supervisors approved this application subject to a series of conditions.
Right.
And someone finds it.
Okay, July 3rd, it's on 29.
Thank you.
29?
Thank you.
I did it 29.
I think it was counting, isn't it?
Yes, it is. That's correct. 29 and counters. Okay. Down in the bottom, the board set a limit of no more than 20 self-propelled vehicles to be located on the property, with not more than 10 to be tagged vehicles for over-road use, and of the latter, the maximum size shall not be more than 2 tons. That is not, if you read that, that is not talking about the delivery trucks. That's talking about the trucks on site, to be located on site. There is no 2-ton limit on the trucks that are bringing in the logs. It's not there. And so that again, is not something that is appropriate as an objection. Now,
Before you go on,
Yes, sir.
I have a quick question on that very point, because when I read this, that's what, I mean, you were there, right?
Yes, sir.
When it was originally granted. My reading of it was that the original permit was there was going to be a bunch of vehicles and equipment stored at the lot in connection with the other part of the business.
Just
And that this
Like
condition,
snow removal.
like snow removal and all that, and right, and that this condition on the size of the trucks was only the size of trucks that were gonna be stored there or parked there overnight and such as that. Is that?
That's certainly my understanding, and I realize I'm not sworn, I would be glad to be so, that was my understanding, but that's the way I read the limitation. Because at that time, that's what it meant. Now, let's get to the contractor's yard and whether or not it's an allowable use. The test, as Mr. Goff talked about earlier, is whether the use is fairly debatable. I mean, if it says you can't stow a log somewhere and then you give a permit to stow a log somewhere, well then obviously it's not fairly debatable. But it talks about the definition of the contractor's offices, shops, and material storage yards. If the use is fairly debatable, then it is an allowed use unless it's been appealed to the circuit court as it should have been, and it wasn't. It says establishments for the construction and/or repair of buildings. Last time I looked, a lot of those logs might be turned into materials for the repair of buildings. Or roads. The permit talks about the allowing of vehicles for snow removal, which is part of the road. Utility lines, servicing of heating, cooling, and electrical equipment. First 20 years I lived here, I heated with wood. A lot of that's firewood that's there. Then it goes on into electrical equipment, flooring, painting, plumbing, roofing, tiling, and/or excavating, which some of this equipment can also be used for in terms of the snow removal and repair. And also, he's talking about tree removal when he first got his permit. Tree removal from where? Roads, buildings, whatever. The use is a fairly debatable use, and so I submit to you that the authority suggested by council that this was not such a use that it could be subject to the vesting statute is wrong. It's just wrong. This is a fairly debatable use under the zoning ordinance of Rappahannock County. And it wasn't tested in court. It's presumed to be valid unless it's not fairly debatable, which it is. It is a vested use. It was not appealed from 30 days of 2007, 30 days of 2012, or even 30 days of 2018, when the Board of Supervisors said, we don't need any more reviews. And that's what they did. They said, we don't need any more. We will let the zoning administrator, if there are violations, she can investigate them as she would any other zoning violation. Look, there's no question but that some people don't like the piles of logs and don't like the fact there are trucks on that road. But that was all considered in 2007. The Board of Supervisors looked at it. I agree, you don't have the authority to overrule the Board of Supervisors. You do have the authority, if they have standing, if the appellants have standing, to decide whether or not the use hasn't been enlarged, or whether or not he's moved his logs back from the road. That's about all you have authority to do. And I submit to you, there is no evidence that the business has been enlarged or intensified or extended. It's on the lot it was approved to be on. It's actually smaller because he moved his logs back when they found he had violated. It has not been extended, and there's no limitation on how many logs he can have there. And there's no real competent evidence here about whether it hurt property values or matters like, or even the quality of life, because those things should have been raised in 2007. And so there just is no authority here, I think, for an appeal at all, because Mr. Freitag and Ms. Hardy are not suffering any other damages other than what everybody else along that road and everybody else who drives that road can see or hear. Thank you.
Thank you.
Probably the next person. Art and Michelle are the same person for all intents and purposes. They're both here representing our county.
Art had to leave.
But he's gone. Okay. Michelle, do you have any rebuttal? No? Okay.
Well, I have a question of you. When you went out and saw that the logs were, we saw some pictures where they were right up to the stone fencing and so forth. Did you walk the perimeter of the operation or plat?
I had Mr. Williams show me where the property lines were.
And so did you take the measurements only there at the road, or did you take?
That was the closest point.
So when you looked, you just further, at some of the others, you just were kind of eyeing it in and saying, well, that looks like it's, but you actually measured in one place, but not in all the places.
Okay.
And then, was there a lot, did you notice any of the noise, the buzz sawing, chainsawing?
There was no noise available there.
Must be Christmas.
Christmas.
Action.
What day were you there?
Ron had a question.
When we're considering the setbacks, which takes precedence, the road or the property line?
For the front, you're referring
Along
to
the
the
roadway,
lot.
right.
It was from the edge of the road.
Okay.
So that's more than the property line.
Right, but it says both, and it's a little confusing the way it's written, in that it says the road or property lines, but the property lines don't ever follow the road, but so on the roadways, it's a setback from the edge of the roadway, not from the property line.
Thank you. Yes, public I guess open the public hearing. Okay, I'm going to open the public hearing right now. And what I would ask is that we keep the comments relating to this case and this appeal. So, and I'd like to limit it to 3 minutes. And anybody who would like to speak? Is there anybody?
I could say a word.
You can identify yourself.
My name is Leonard McGill, and
Actually, could I see a show of hands of who wants to speak? All of you again?
Quickly,
Okay.
rebut.
What I'm going to do is I'll swear all of you in, and everybody who wants to speak.
Jury.
You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
We were already sworn.
Okay, well, there are others that may not.
Leonard McGill, I'm at 374 Benvenue, so it's catty corner from Greg's operation. Just a few things that I don't entirely understand. You got the permit in 2007 for what then was evidently a modest collection of businesses, and it's just morphed into what is now a heavy industrial operation with significant collateral damage to the neighborhood in terms of incessant noise, which my wife Lauren talked about, the safety issues every time we leave our driveways, and massive provable deterioration to property values. And so this Williams Tree lumber business is an industrial use in an agricultural zone, and it should be moved somewhere else. It's clearly outgrown its original use. And what I don't understand is he came to the Board of Supervisors when he got a site on 211. He has a site, it was a former E-Town site on a commercial strip. And he said at the time he was going to move the substantial part. It wasn't Frank Reynolds at the time. He was represented by Michael Brown for that hearing. And he said he was going to move the substantial part of his business to that site, which is appropriate. It's a commercial site. It's on a 4-lane highway. And as a result, he got his conditions reduced at the Benvenue site because he was going to reduce the operation. Well, he never did move, to my knowledge, the substantial part. He moved some of the equipment, I believe, he parks it over there, but he didn't move this lumber business to that site. In fact, he's exponentially expanded it. So what I don't understand is why we're not all working together. Now this is no longer fits where it's at. No longer fits that. It's a historic, scenic byway, designated as such. And so I don't understand why he's not moving to ECOM, or that we're not working together to find him a site that's appropriate, more appropriate for his operation, to work peaceably and profitably in some other location within the county that would work better for him and for us. And it may be that if we could avoid all the lawyer fees and all the litigation that we're all careening towards. I'm a lawyer myself, so I'm all in favor of lawyers, but it seems to me that this county spends so much time avoiding taking action and enforcing its own code and resulting in litigation. There's a small group of lawyers in this county. in this room that spend a lot of time suing county officials for not doing their job. Do your job. Find a site for Greg Williams where he can operate within the county, which is an industrial site, and take the lawyer money that you're gonna spend and send it over and help him move, and we'll give him time to move. We're not interested in putting him out of business. I realize I'm out of time.
Thank you.
You also moved there 1 year ago?
Yes, sir.
Okay, thank you.
Thank you.
Who's next? Bill?
Can they just stand and just make a comment, or do they need to keep coming forward?
Just go ahead and come forward. It's only.
Good exercise. What is
I don't need to go through an introduction again, do I?
No.
And my points are just a couple. One is, I want to reinforce what Len just said, and that is, our goal has never been to drive him out of business. But it's been our goal to get his business out of our neighborhood. Because it's not appropriate for what our neighborhood is. And Frank Reynolds' point about this thing wasn't contested in 2007, or 412, whenever the hell it was. You know, I feel guilty about that, but being a naive, relative newcomer to the county, I sort of took it at face value that when a government official stands up and says, oh, this is the way to do it, that he probably knows what he's doing. And then when he sells it to the Board of Supervisors, I believe the Board of Supervisors know what they're doing too. Well, I really feel disappointed that I've been lied to now for some almost 20 years. And if we want to do things right, and I think Gift point didn't make that point, that was when the operation at the Williams Tree Service site is not one where thousands, millions of dollars have been spent building edifices of some sort. It's a goddamn piece of bare property that's now been populated by pyramids made out of firewood. For him to move his operation can't cost more than a damn nickel on $1,000 for him. It's not going to be one of these things where he's going to lose millions of dollars in invested structures and that kind of stuff.
Okay.
Thank you.
Thank you. Who's next? Mayor. You can identify yourself.
Mr. Chairman, I'm Sandra Renzi, 392 Benvenue Road. I live next door to the McGills and across the street directly from the Freitags.
Okay.
So I'm catty-corner diagonal away from it. I've lived on Benvenue Road since October 2007. Shortly after moving in, I began observing the noise and activity 3 doors down. Mr. Williams had been granted a special exception permit earlier in 2007 for a commercial operation out of his own residence. After reading minutes of the July 2nd, 2007 BOS meeting, I was encouraged by item 12, quote, "The permit shall be reviewed every 5 years." That's Exhibit D, page 23. A couple of years later, in a March 26, 2010 letter to John McCarthy from Mike Brown, attorney for Mr. Williams, page 19, Mr. Williams applied for another permit to, quote, "move the vast majority of this business to the subject property being former ECAL site routes 211 and 729. I have the entire quote, but no time to read it. Also, in the last paragraph, Mike Brown concludes, quote, "by relocating, quote, the substantial portion of his existing business to this location on US Route 211 and 729, we believe this is in keeping with several of the policies expressed in the Rappahannock County Comprehensive Plan. In September 27th, by the way, 2012 letter to the Board of Supervisors, Frank Reynolds, attorney for Mr. Williams, succeeded in removing conditions of screening and setbacks by comparing this business to that of Sawmills, page 26. Also, in the third paragraph, page 25, quote, Greg has brought to pass his stated plans to move a good deal of his operation to a major thoroughfare. John McCarthy's August 30, 2012 letter to the file and neighboring property owners. Quote, since issuance of the permit, Mr. Williams has secured the Benvenue location for his operations, rendering many of the permit conditions on this site moot and or allowing him to request a reduction in the intensity of the use, page 28. A previous speaker referred you to the powerful photographs taken of the small piles of firewood at the Williams Tree Service Benvenue site in 2010. Those are photos, pages 51 to 55. Can you honestly conclude that the vast majority of this business was moved to Route 211 when you also view the vastly expanded piles of cut wood, logs, mulch, and equipment shown in photos 56 to 64? It's clear to an objective observer that didn't happen. The giant wood piles keep growing and growing. There are apparently 5 to 8 full-time workers on site in direct violation of the original set, which capped the workforce at 3. In order to feed the wood pile and service its customers, the operation requires constant visits by 18-wheel tractors pulling double trailers full of logs. See the truck photos, pages 69 to 73. Let me end with, I don't want to put Mr. Williams out of business. I want to put his business out of our neighborhood.
Okay, thank you. Who's next? Is that it? Okay,
I just have a couple quick things.
okay.
Hi, again. Thank you. I just wanted to make 4 quick points in response. Number 1, even if you don't think that what I had talked about before shows an enlargement as far as the pictures or maybe the property line extension, I do think that if in 2012 Mr. Williams only needed 3 workers, but now he needs 6 to 7 to 8 daily, how is that not an increase in operations? It's impossible, common sense. It has to say there must be something going on because he asked himself in 2012 for 3 workers on that site and it became part of his permit. So that's one thing. Another thing about the 2-ton trucks, yes, Mr. Reynolds referred to them being located on the property. And again, I just ask you to use your good common sense. The pictures that I took of, double logging huge trucks, they were located on the property. So I think that that's also, if you can't prove that the truck that I took a picture of is on the property, I don't know how that's not a permit violation. And then I ask you to concentrate in general tonight on what is in Mr. Mann's initial complaint, to which Ms. Summers responded, and we are then appealing. Maybe more importantly also what is not in Ms. Summers' response that we actually initially asked about, like the 2-ton trucks and some other things. Tonight, Mr. Connick brought up code 170-53, which Mr. Connick tonight said that all SEPs, it applies to all SEPs. And 2 of the things on there, I just asked if Ms. Summers' site visit looked at the protection of the surface water and groundwater, as well as sound limitations for it says for peaceful enjoyment of neighbors. So that was one thing. And in conclusion, I've already stated this for two bodies, the Planning Commission as well as the BOS, and I will repeat it now for you. We are not here to shut down a local business, nor are we here out of enmity toward the Williams. To the contrary, I really respect this family very much. We have just witnessed an incredible expansion that no one in 2012 could have imagined. It has clearly outgrown its Benvenue site and needs to be taken to an industrial zone where it belongs. We are happy for Mr. Williams that his successes have brought such expansion, and we respectfully ask you to acknowledge that his permit is now violating the enlargement section of the County Code 17050. Thank you.
Okay, thank you. So is it one more?
Y'all are just not even listening anymore, right?
I'd like to
Waiting
read Jennifer's letter.
We're not going to let them.
We
have
all
the
read it.
letter.
She's got 3 minutes of letter.
Okay, read the letter.
Yeah.
We all read
Hey,
it.
it's okay.
Yeah, but it's not on the tape.
Go ahead, she can read the letter.
Mr. Chairman, once again, I ask that you do not continue to turn a blind eye to the industrial operation that continues to function on Benvenue Road at Williams Tree Service. For those of us who have homes on Benvenue Road, we find our neighborhood, our property values, and our safety is at stake. My family purchased property on Benvenue Road in 1964. It was a small, quiet area with little traffic traversing the road. Now we contend with cars that use Benvenue as a shortcut between 522 and 211. Add to that the traffic from commercial trucks and tractor trailers that are simply too large to safely travel on Benvenue Road. You have now made our journey from our properties more than challenging. It's simply dangerous. In an area designed to be agricultural and residential, we now contend with industrial operations that have degraded our scenic road into a dangerous passage. Not to mention the degradation of our land values, as now our neighborhood includes an industrial business with ever-present heavy-duty equipment. Properties on Benvenue were once highly sought after. That is no longer the case. I believe that the failure on the part of the Board of Supervisors and the zoning administration to properly enforce the county codes has negatively impacted my property value and that of surrounding properties. Our property is one of several that remains unsold after a lengthy listing time, even with the listing price lower than the appraised value. Other neighbors' properties have taken years to sell, with many going unsold. And I just want to add too, that we don't want to drive Greg out of business. We want his business to thrive in a more appropriate location.
Okay, thank you very much.
Do I understand?
Yes.
We already have it.
Thanks.
Okay, I'm closing the public hearing. Okay, the next issue is are we...
Wait a minute, Mr. Chairman, before we do anything else, could we clarify, because I know I'm the secretary, so I'm supposed to be doing this, but have you moved your entire package into the record? And if not, do you want to do that now?
Are you talking about this?
Right, all 103 pages, or what, I mean, a lot of it nobody talked about, so.
Well, I certainly will do that if necessary. I wrote a letter asking to be made part of the record, but I will say here now, I ask that
I just want to
it be made part of the record, and I appreciate the opportunity.
Okay.
Okay, and Mr. Reynolds, your letter is part of the record?
Thank you, yes.
And Mr. Goff, tomorrow, he didn't submit anything?
No.
Okay, is there any other, besides the sure shell letter, we're going to admit that?
There was another picture or two that,
The picture.
that's not in there that had the writing on.
Okay, who submitted that?
That was from.
I think that's in the
That's in there, but this has more.
Maybe you just passed it around and then took it back.
Was it Patty?
No, you said the one that you took a few minutes after some other picture.
Yeah, that was
Did you
the
give
one.
us that, or did you
I
take it
did
back?
actually.
We've got it.
No,
It's a glossy, it's a large glossy.
I handed it back to Mr. Hampton.
A laminated, I
One
should say.
copy.
Sorry, laminated.
Well, I mean, if you want it in the record, now's the time to put it in.
Thank you.
Okay,
Right.
thank you. Is there anything else?
I'll just clarify that our filing should be part of the record. We had an initial filing, we had a supplemental
The
filing,
appeal package and.
supplemental, and there was a response to Mr. Reynolds. All that's part of that package as well.
What is
Okay.
that? What is this?
You missed, wasn't part of the a little bit of presentation.
If you read it out loud, we can get it on tape.
Then it's in the transcript. We don't have our, okay. All
I
right.
didn't read it out loud.
Could I put in the other document that I handed you of the documentation of the permit violations of the
She has
workers?
I think we have that.
Okay.
We have it, but do you have it?
It's right here.
Happy part of the
Rest
record.
of days and...
Yeah, she has.
Yeah. Okay.
Are you numbering those? Go off the record. Off the record. What are you doing with all this?
I just put mine on and then go back and.
We think everything's on the
You're
record.
gonna list them as them.
So you're taking care of that?
Yes.
Great.
Okay, so the question to the board is, as far as proceeding, do we need to get some advice from our legal counsel?
I move that we go into executive session for a discussion with council. Under
Do you want-
2.237.
Do you want me to read a motion and you can say so moved?
Why don't you hand it down? Just tell me what number, 3711, right?
2.23711 subsection A8 for purpose of consultation with legal counsel employed or retained by the BZA relating to specific legal matters, specifically with Mr. Lockley for advice regarding the legal issues in the appeal brought by Ms. Hardy and Mr. Freitag.
Is there a second?
That's just what I was thinking.
Is that-
I'll second
the
it.
words right out of my
Okay, we
mouth.
have a second.
Second.
Any further discussion? All in favor?
Aye.
Okay, so we can go into this room up here?
Or we can kick them all out.
Yeah.
Eject is the word.
We'll go into this room.
More of us than you.
I'm sorry.
Is that on the video?
I'm going to call this meeting back to order.
Well, that sounds like it was in complete disorder.
Okay,
Mr. Chairman,
we're back in order. We're back in session.
Mr. Chairman, pursuant... Oh.
I'm sorry. You might need this.
What? Me?
It's a-
Mr. Chairman, pursuant to section 2.23712 subsection D, I move that the BZA certify by roll call vote that to the best of each member's knowledge, only public business matters lawfully exempted from open meeting requirements under section 2.23711 of the Freedom of Information Act, and only such public business matters as were identified in the motion by which the closed session was convened were heard, discussed, or considered in the closed session. Just like we take a roll call vote.
That was a motion. Is there a second?
Yes, I second that.
Now you have to take a roll call.
Okay, now the roll call, Jennifer.
I affirm all of that.
I affirm all of it.
Me too.
I affirm.
Chris?
I affirm also.
Okay, so we're now out.
Okay, so now we're back to
Closed
this.
session.
What is that?
I do.
What else?
Okay, so there, in my understanding, we have, first of all, the issue of standing and to determine whether our board feels that the appellants have standing to make this appeal. And I'm willing to hear a motion.
I move that we affirm that they do have standing.
Is there a second to that one?
I'll second that motion.
Is there any discussion? No discussion?
I guess my question is, I think that there's two questions. Did they appropriately move the standing in the appeal filing? And have they demonstrated it here at the hearing? So that would be my comment, but I'll do whatever the board wants to do. So
Okay.
here is a general
Because we're
motion,
making
as I
a
understand
finding.
it,
It is
that
a
we're
general
just
motion.
make
They
a
have
finding that they have
Adequate standing to make
that whatever.
to be heard.
Okay.
All in
Thanks for
favor?
the clarification.
All in favor?
Aye.
Aye.
Abstain.
Okay, the vote is 4-1. So we agree that you have
4-0.
4-0. I'm sorry, 4-0.
And one abstention.
One abstention.
Mr. Connick.
Now, the second, and I look at it as two issues, but they're kind of rolled into one. the vested rights issue, as I understand it, is whether we can find or agree with Michelle's ruling that the permit was granted and that the permit holder has vested rights because of the fact that it was not appealed within the statutory appeal period, which would be 30 days. And we have the other, you've given some other information as to why that may or may not apply. I think if, and I may not be speaking for everybody, but I feel like that it was done at a public hearing. It was noticed, and the conditions and the permit as described were described. So I feel like that there was public notice and it was done in a public forum. That's my feeling. I don't know if you have anybody else wish to comment? David? No?
Well, I think that the board's authority is limited, and my own feelings are really that I don't think a zoning administrator who is an agent and an employee of the Board of Supervisors has the legal authority to pass judgment on whether what her board did before she ever worked for them by about like 8 or 9 or 10 years was legal, or void ab initio, or any other such thing. I think that a zoning administrator has to take these permits that have been issued by her superior authority on the assumption that they're valid. And because, well, you know, we have a lot of presumptions in the law. There's a presumption that people are sane, not that people are insane. If you think somebody's insane, you have to prove it. If you think somebody's guilty of a crime, you have to prove it. There's a presumption that people obey the law. That's why there's a presumption of innocence, because presumably people will obey the law. That's why there's a presumption that legislative acts of the Board of Supervisors or the General Assembly or anybody else are valid and constitutional unless and until some court says otherwise. And so think of the mess and chaos you would have if, especially in this particular type of instance, where in 2007 the lawful board of governing body of this county issued a permit, and here comes Michelle Summers in 2018 to tell that board, hey guys, you know what you did back then was totally illegal and wrong. And by the way, I've been looking through the files and see a whole bunch of other permits that I think, you know, should never have been approved. And we just have utter chaos. And the law doesn't look with favor on chaos. The law looks with favor on order. And this would just create disorder. And that's exactly the reason why Code Section 15.2 2285F is in the code, because it says if you're not happy with whatever decision they make, you have 30 days to go to the circuit court and appeal it. And so maybe I'm jumping the gun to somebody else was going to say, but you know, I have to say, if I was on the Board of Supervisors in 2007, I would have never voted to approve this permit. I think it's an example of exactly why a Board of Supervisors should never have the authority to issue these permits, because they don't follow the ordinance. They do it on politics, and they do it because so-and-so's a nice guy, or maybe so-and-so is David Connick, and he's a horrible guy, so we're not going to do it, or whatever. And that's what I alluded to earlier. That shouldn't have anything to do with it. you go by the ordinance, and I don't think they went by the ordinance. I don't think they took into consideration the conditions and the requirements that are in there. I don't think that they took into consideration exactly what has happened. When I came here in, 80, I was going to say 85, but it was way before then, I'm sorry, 75. On Benvenue Road, there was about 4 houses where all you people live. I could name them off, starting at Eastham's and ending up at Dr., what was his name there, in the stone house on the corner? Rogers, right. And in between, there was about 2 or 3 other houses, including Eddie Sutton's, which I think is where one of y'all live. And that's it. And Williams was there. And that's it. All those other houses were built since that time. And it's something that's ongoing. And in granting this permit, I think the board should have foreseen that kind of situation. They should have taken into consideration the road. In my opinion, they're required to do that before granting the permit, but they didn't do it. And for those and probably some other reasons, which I need not go into, it was probably a permit that never would have withstood scrutiny if it had been appealed. And in 2012, and also I want to note that I looked through all what Mr. Hampshire filed, including the Board of Supervisor minutes, and many of you who are out here in the audience today, including Ms. Herschel and even Mr. Makala, who was just a citizen at the time, testified at those hearings and said all these same things, or predicted that some of these same things were going to happen, or stated that they didn't think the conditions were adequate. And basically, they were ignored. And, I don't think, for what it's worth, that decision would have withstood some scrutiny if it was challenged. But it wasn't. And to me, that's the end of an awful lot of this appeal. I really feel badly for you, and I agree with an awful lot of what was said. I'm not disputing any of that. But this board, as a board of zoning appeals, has very limited authority. And I don't think we've got the authority to basically say what I just said, or act on what I just said. That's my opinion, but I don't think I have authority as a Board of Zoning Appeals member to say to the Board of Supervisors, you guys, botched another one.
Okay, thanks.
So, that's my view on that. I don't think we can, I don't know, I'm not going to I don't know what the motion's going to be, but I don't think we should consider that, because I don't think that Michelle has authority one way or the other as zoning administrator to countermand what the people she works for already decided to do.
Okay.
So if you want a motion from me, I'd make a motion that we deny that part of the appeal.
Well, let's just see if there's anything else. Ron, do you have anything to say? No? Yeah.
I mean, the time limits have passed the appeals time and all that, but there's a wrong there, and I don't know we don't know exactly how to make it right, but we, as a board, can make it right, but we know that there's some pathways to get to right.
So should we consider a motion?
Well, I said a name.
What was your motion?
My motion is that
we don't have
everything about I don't think we should act on the vested rights part of it or the void ab initio part of it, because I don't think we have lawful authority to do those.
So we could do
either of those things.
And is that a motion?
Yeah.
Just to lay it aside because we're not able.
We're not laying it aside. We're not.
We're not going to act on it.
If we agree, is there a second?
I'll second that.
Is there any further discussion? All in favor?
Aye.
Aye.
Okay. Now, the last issue is the evidence of violation and Michelle's findings of violation. And I think that there is some evidence potentially of violation. It's just, can we prove that any of that was evident to Michelle's viewing? I don't think that violations are something that we are ruling on permanently. And I think there may be some recourse beyond us back to the Board of Supervisors. If there is violations, I think that's really the appropriate place to go and make a request to the Board of Supervisors to review it or potentially to revoke. I mean, they have the power to revoke the permit. We could speak to that, but it's not really that much we can do.
You know that they sent us here.
Yeah,
Yes,
yeah,
okay, yes.
which is a little nuts.
Well, they don't have authority to send anybody anywhere.
I was going to say, can we address just the safety issue also briefly, in that that road, without Greg Williams being there, is an incredibly dangerous road. And it's been that way for years.
Forever.
And I would strongly encourage the residents on that road to go to the state and ask them to come in and make improvements on that road, because there are, I mean, it's a lane and a half in a lot of spots on the curbs and whatever, and the state has just ignored that for 50, it's about as wide as it used to be when you had the toll gate down there probably. And it's just, you know, that's not Greg Williams' problem.
That's an idea.
That's not Greg Williams' problem. I mean, you know, and that the road is what it is, and the logging trucks, I've got logging trucks on my road daily right now, because with the land use, people have to, you know, have to harvest the timber, and they've got to get the log trucks in there someplace in order to do that. So their log trucks are on the roads all through the county, and in certain places, that's the only, just the way you could only get to your house on that road, that's the only way they can get to a pickup point for a logging thing or whatever.
Well, that's why he should be on a super highway.
But
That's
why
fine.
I'm
That's not.
no, you're not, I'm talking about cutting of trees on property.
Okay, what shall we do with this last issue?
About the violations.
About the violations. I think you ought to go through whatever's in Mr. Mann's letter, and there's also one other issue, and that's the expansion. So that's another issue other than the violations.
Well, that was sort of wrapped into the violation.
Moving it into.
I think we ought to do that separately, is my suggestion, but whatever the rest want to do. But I think when we get to the alleged violations that we heard, I think you ought to go through the letter or make, you know, what they are.
So what are we going to determine?
And then go through them one by one and have a vote on every one of them. Was her finding correct or incorrect? What's in her letter?
And she only made one finding, really, which was the setback.
Okay, but, well, whatever they are, I think we're to go by the letter and by what she responded to. And go through and make a list. It could be that hard. Just go through it, issue by issue or violation by violation, and decide whether the zoning administrator's determination has a presumption of correctness, just like what I was talking about before. So we have to take a vote on whether the appellants produced evidence that her determination on every one of those alleged violations was wrong. And if they didn't produce evidence to convince the board that they were wrong, then I think you have to vote to affirm the decision, or at least that part of it. And I think you would do it. But you can do it either way. Do it all you lump them all together, or you can lump them all separately.
Any other thoughts?
Well, the way I would approach this, and what I'm coming up with is not necessarily the complete list, but it seems to me that we have been given testimony to the fact that the allowed truck usage has been the trucks have gone beyond the original permit. The use of the property has been enlarged remarkably in the last 5 years, and as far as I'm concerned, the actual use of the property is different from the original permit. And I would be able to vote that all of those existing uses are violations of the permit, the original permit, and that the supervisors ought to take that into account and fine accordingly.
I agree, because the trucks, the size, the number of the trucks, the number of workers, if they've gone up to
That too.
eight instead of 3, well, that's doubled. So that's an expansion. The level of the noise, the hours, the weekends, all of that tells me that they've got a booming business out there instead of a couple of guys.
Was there anything said about weekends?
I asked twice, and they.
No, in the permit.
No,
No, in the permit, no, it was not. They didn't, and so things that have come before us as a PZA, we put decibel levels on that can be, cannot go above that, weekends, and, those kinds of things. Whereas that did not get addressed at the Board of Supervisors, because we do have a noise ordinance and a lighting ordinance and so on.
But that was not addressed.
No, that was not, because it didn't come to us.
I was going to say, I would have a hard time voting on violations that are not more specific. Right now, we're talking about sort of generalized violations.
And I agree. I mean, I get that, because it's not in there, but.
Well, I just think a big general discussion like this isn't very helpful.
Well, we'd like to resolve this.
Well, I say let's get out the letter that she wrote and go through it.
You're talking about Michelle's?
Michelle's letter, and let's lay, and here's on page 022 is the conditions. And let's go and have a vote on every one of them. And let's go home.
Except for the hours of operation, except for.
Wait a minute, let's get the letter out. Which is the letter? All right, let's do the intensity of the use has increased since the permit was issued, causing a violation of RCC section 170-50B. Use shall not be enlarged, extended, increased in intensity. The Board of Supervisors place conditions upon the SE permits pursuant to RCC, which is Rappahannock County Code 170-53, and at that time imposed horizontal setbacks, limits on hours of operation, etc. There were no conditions set by the board that would limit the number of pile stacks of firewood or the height of pile stacks. To this end, I do not believe the intensity has increased to the extent that would trigger a violation of RCC 170-50B. So, let's do that. That's the first bullet we already disposed of. So that's the second bullet on Exhibit A of the appeals package. Let's have, I don't know. You want to have a motion, or somebody want to?
Why don't you make the motion?
Well, all right, I'll address them one at a time.
Do you want me to read 170-50 or?
No, I don't think those are relevant. I think the only thing is to turn to page 22, and this says what the conditions were. The hours of operation. It says except for the exceptions set forth both in paragraph 2 below. No company vehicle or equipment will be started before 6 a.m. on any day, and the latest to return to the property will be no more than 1 1/2 hours after sunset. So, just as far as I'm concerned, I didn't hear any testimony whatsoever that is enough to overcome the presumption of the validity that that's been violated. I don't have a date. I mean, there's some pictures in the file, or in the filings, and, that, I don't think that's violated. I don't think there's any evidence before us that that was violated. 2, exceptions. Between November 1 and April 15, vehicles may be started and run when called out for snow removal. I don't think we had any testimony about that.
Because he moved his operation.
All right, B, when called out for emergency storm damage, vehicles may be started and run, but no more than 2 for that purpose. I didn't hear that. 3, material storage. Firewood and logs no longer than 16 feet may be stored in the on the premises at least 50 feet, which I think was changed to 25 feet, from any property line or public road, and said logs may be cut into firewood length on premises, but only between the hours of 7 a.m. and 6 p.m.
We heard testimony that it was longer.
Okay, all I want to say is it's obvious to me that from that the logs longer than 16 feet that were going to be stored there and cut into firewood length were going to be brought in from somewhere else, because obviously they weren't growing there, they weren't being cut there, they were being brought there. There isn't one word in here, not a word, about what size of trucks could bring the logs. And obviously that trucks had to be big enough that a 16-foot log could be put on it. The next material storage thing is wood and chips and mulch may be stored on the premises at least, again, 50 feet, but I think it was changed to 25. From any property line or public road, wood chips and mulch may be created on the premises, but only between the hours of 7 a.m. and 6 p.m. I didn't hear any testimony at all about chippers or mulch. So I didn't hear any evidence about that. And I also, again, want to say this, this is something that is very specific. It's in here, and I didn't hear any testimony to the contrary or see any pictures. There's no limitation on that or the logs about the square footage or how much of the lot they could put it on, or 100 square feet or 25 square feet, or no wood piles taller than 10 feet or 8 feet or 50 feet, or if snow starts falling on the top of them, I didn't hear anything. There's nothing in here about it. So I don't see where there's a violation of that. Equipment storage, that's pretty much a moot point. That's where they talk about the size of the trucks, but that's all been moved down to the other place. Proposed storage building, that was taken out, and because they never built it. 6, any vehicles entering or exiting the property will do so only on VDOT approved entrances. I didn't hear anything about that. I didn't hear whether the entrance was or wasn't approved, or whether any trucks were coming in or out other than on an approved entrance. Not a word. No, 7, no burning of brush or debris connected with any of the business operations. I didn't hear a word about burning brush or debris. That's not in the letter, and it's not in either letter. It's not in the complaint letter, and it's not in the opinion letter, the determination letter from Michelle. 8, the storage building, etc., they didn't build it, so that's out. 9, except for pickup and drop-off of employees for work elsewhere, no more than 4 persons working on the site at any one time. And that was changed, all right. These changed to 3, okay, so it's 3. These persons shall be performing maintenance on equipment, management of mulch and wood areas, and occasional loading of mulch or wood onto customers' vehicles. Okay, I didn't hear any testimony about that.
Well, we did get that list.
I didn't. I heard about about the number of people, but I didn't hear what they're doing.
Well,
10. Well, the evidence is closed.
They were chainsawing.
Can I finish without getting interrupted? 10. The applicant shall provide screening. They took that out. 11. And this is about the size of the trucks. There shall be no more than 20 self-propelled vehicles located on the property, with not more than 10 to be tagged vehicles for over-road use. Of the latter, the tagged vehicles for over-the-road use, the maximum size shall not be more than 2 tons. We don't have any, this is located on the property. This isn't making deliveries. We're driving in there and driving out. This is when it
Well,
was
they
a
certainly
storage.
don't stay there.
Well, it was when it was a storage lot. Remember, this was permitted for a contractor's yard for storage of his vehicles. And that's what that's about, not about the size of vehicles that are making deliveries or picking up wood and taking it away. And then last but not least, the permit shall be reviewed, whatever that means, every 5 years. So, based on that, I have to say, I agree with what Mr. Reynolds said about when you give a permit for a use on a property, and I think it's right in the zoning ordinance, you can extend it anywhere throughout the property or the building that is permitted for, and unless they put a contrary condition in. And they didn't, unfortunately, and what can I say, folks? I'm sorry I wasn't on the board then, sorry.
We're done with the public hearing.
They didn't do it. And this board doesn't have authority to try to patch up a lousy permit that should never have been issued. We just don't have the authority to do it. All we have before us, and the only authority we have, as I read the law and as we've been advised by counsel, is to say, is what Michelle Summers wrote in her letter about she did not see these, any violations or an expansion beyond the conditions that were permitted. And I think the answer to that, all those are no.
Do you have a motion to make?
I'd like to discuss a little bit
Well,
before
don't we have to
that.
have a motion?
What I see,
You have
everything Mr. Connick says is true. I don't think anybody is accusing Michelle Summers of trying to overlook, railroad, or otherwise misrepresent anything. My experience, what I learned in this meeting was that there was evidence as to the intensity of the use, the hours of operation, the number of workers, and the size of the trucks. Those are all in violation of the original, amended permit. And as such, I would say that these conditions were probably not visible to Michelle Summers when she was there, but they have been brought to our attention that they are the case. And so in what I would think we should do is find that the use and conditions of the permit should be investigated and verified. And that isn't accusing Michelle of any wrongdoing, but that it is something that better evidence than we have ought to be presented, and that this ought to be done to the supervisors, because they are the ones who can make the decision.
I agree. I asked her several questions. How, were you on site 1 hour? An hour.
No, they can't do that. You can't do that either.
So if she was on distance, I was supposing she would be there about an hour. She can't see everything that goes on from 7 a.m. to 6 p.m. and all the time in between, and whether they're chipping or making mulch or something. We heard from a witness that there was very loud click, click, click noises and the backup beep beeps of the little Kubotas and so forth. So it was probably quiet, and she was there, and she didn't see that. But I believe the testimony that was given by the witnesses as well as by the appellants, that there is an expansion and a violation. I drive by there. I don't tell my husband now because he doesn't want me to drive that road.
And I want to make sure and clarify what my advice was with the two options that they had. If there's a pattern of continuing violations, that might very well be grounds for the Board of Supervisors to take a revocation action. I think that's what Mr. Connick is getting at. If there are individual violations which the zoning administrator happens to see, she can bring an enforcement action to bring a person back in the line. So just to be clear, it could be the Board of Supervisors, it could be in individual instances, the zoning administrator and Mr. Goff bringing enforcement.
So the one that she notified them has been brought back into line. That's our understanding.
I can say but the violations to me have to be verifiable somehow, and we can't, it's impossible in Rappahannock County for the zoning inspector to go out there and spend a week observing, the operation out there in order to, gain enough evidence to really, support these violations, and that they're alleged right now to a certain extent, and they may in fact be factual, but I can't, you can't say that for sure by just looking at a piece of paper and it's got some numbers on it.
People can verify and people can provide evidence.
That other people can, yes, but it has to be evidence that is, a picture of 9 employees, sitting up at your house and just making that record. We don't know if that's accurate or not. I mean, you can sit in your house and you can write anything just to make it look good, and that's the problem we fix.
The problem that I've got with it is not that, because these people, I think, are honest people of great integrity, and assuming I believe everything that they said, the problem that I've got with the way they presented that evidence is they admitted they never gave that to Michelle. So Michelle has no way to verify it. And at the time that she made her determination. And so I didn't hear that, if I'm mistaken, maybe I'm mistaken, but that's not what I heard. I specifically asked that, did you give that to Michelle Summers? And they said no. So there was that part of the Mann complaint, and the answer I thought was no.
You've got the letter in there, and the letter showed a lot of those details that weren't responded to.
Okay,
we're
I'm talking about the specific list of people and the dates that various employees were there. That's the problem I have with it, the same as what Mr. Mackel was saying. I think for us as a board to overturn a decision that has a presumption of correctness, look at the zoning ordinance and the state law, that's what it says. We've got to have, I think, pretty clear and convincing evidence, or at least a preponderance of the evidence, that what she went out there and saw and found was erroneous. And maybe she didn't see it, or maybe other things are happening when she wasn't there, but on that particular date, when she went out and made her inspection, she didn't see it. And I don't think, that's, to me, speaking especially as a former zoning administrator, that's a terrible precedent. To put the blame on Michelle Summers that she didn't see all this, or make the finding. And if, as Mr. Byrd says, and Ms. Matthews seems to agree, there's an ongoing pattern of violation, then I would say that we should recommend to these appellants and the others to look at section 17061, revocation, that says a special exception permit is revocable on the order of the issuing authority, namely the Board of Supervisors. Go to them. Because that, to me, is another very persuasive argument that we don't have authority to do what you're asking us to do. Even if we found that there were violations of the conditions, we don't have any authority to do anything about it. We don't have any authority to tell the zoning administrator to take action. Only the Board of Supervisors does. So no matter how you slice the cake, you've got to go back to the Board of Supervisors and get them to either revoke the permit or amend it or something. I don't know. But we can't do it because over and over the ordinance and state law and the case law says we can't do it.
I think we've got it.
All right.
What would we like to do? Just nothing on this point? Because we really don't have to take an action on this point. We're not required to take an action.
Mr. Chairman, you do have to affirm or whatever it is, affirm, deny, or modify
Well,
the,
if we
The
don't,
appeal.
my understanding was if we don't overturn it, then it is
then it
stands.
stands.
So if we say we don't overturn it,
So we could just do nothing?
is that? I
It
mean, in a
would be better
sense,
to have a vote either to affirm the order,
Vote to do
or
nothing?
to not,
voting to say
not
that
overturn.
voting to say that you have not had, that you do not have sufficient evidence to overturn would probably be better than no motion at all.
Okay, is that reasonable?
Yeah.
Do you want to make that one?
I'll make that motion that we
Don't have
You
sufficient
do not
evidence?
have sufficient evidence to make a ruling
To overturn the decision?
to overturn the decision.
Is there a second to that motion? And
I'll
this is
second that.
related to the violations and the expansion of use. Is that right?
What?
Is this relates to the violations?
Yeah, yes.
And the expansion, all of
Okay.
it.
And the, okay.
Yes, all the violations.
If there's a second, did we get a second?
Yes,
There's second.
you got it.
Okay, is there any further discussion? All in favor?
Aye.
Aye.
Okay.
I'd like to make another motion that the board send a letter from the chairman to the Board of Supervisors on our letterhead, saying that we've heard this, we've heard this evidence, we've heard these people, and we recommend that the Board of Supervisors consider under section 170-61B, well, just B, there's two alternatives stated out there. Let them decide that they should take some action to consider whether or not to revoke or amend this permit.
And is that a motion?
That's a motion.
So if they wanted to gather official data about this,
Well, that's up to them.
No, we're just sending a
We're
letter.
just sending a letter to recommend that they do that.
numbers.
Is there a second to that motion?
Yes, I second it.
Do you care who seconded it? Dennis.
Okay.
Okay. Is there any further discussion? All in favor?
Aye.
Aye.
Fine.
Okay, we'll draft such a letter and send it to the Board of Supervisors.
Do you have some other stuff to do?
We get a copy?
Yeah, sure. Okay, thank you all very much.
Thanks for your time. Thank you.
For your attention.
Okay, is it anything?
I have one final question since you guys are finished.
Okay.
What purpose does this board serve?
Well, I don't know, that's another,
This board, no, in about 20 words, you ought to be able to tell me.
okay,
I'm happy to tell it to you.
we hear appeals to the zoning administrators.
Variances.
Yeah.
Rulings,
And then you do nothing with them.
We hear variance,
Oh, give me a break there, Alex.
Want to do that without the board vote? Second.
We'll continue in the rest of the.
All in favor?